No, I'm sorry for the slightly late start. We had a small technical issue here, which has been solved. And so we may now proceed. I'll just remind the witness that he remains under the oath that he took. It's been some days since he was last in the witness box. And so, may we please get underway?
Thank you, my lord. Good afternoon, Dr. Ahmadi. DFSA does not prohibit DIFC companies from engaging in cryptocurrency transaction, correct?
Does not mean does not allow?
Does not prohibit, does not ban them from engaging in cryptocurrency transactions, correct?
Cryptocurrency is not allowed in DFSA, is not allowing this. Does not allow.
You would agree that DFSA's supervision does not extend to crypto or digital assets, correct?
What do you mean does not extend?
Their regulation, and it's an unregulated business activity
Yes.
for DFSA, correct?
Yes, correct, yes.
So there's no regulation or DIFC law or DFSA soft law which bans cryptocurrency transactions in DIFC. Isn't that right?
We know that's not allowed there, but maybe at that time it was not there. But recently, DFSA, they put it on their website as well.
So,
we know all regulated firms that we know it's cryptocurrency. First of all, before even they get approved by DFSA, they need to be approved by UAE Central Bank as well. So I don't. So this is not true.
your position is that there was a policy within TABARAK prohibiting trading in cryptocurrency. Isn't that right?
There is no policy because we are not allowed to do cryptocurrency. There is no policy on
Can I take you to paragraph 16 of your first witness statement, which is 664, please?
Yes.
You say in the middle of the paragraph 16, you say there is a blanket, albeit unwritten, policy within TABARAK prohibiting trading of any kind of cryptocurrency. This was in force at the time Mr. Turner was employed by TABARAK, and he was aware of this, correct?
Yes, of course. We see, Mr. Salah, since we know as a regulator firm that we are not allowed to do cryptocurrency, so we don't need to have internal policy or anything. It is for all the firms who are regulated. It's not to do special policy for that.
But this unwritten policy that you had must have been conveyed to the staff. It was a very small office at TABARAK. And who had responsibility of conveying this message to the employees?
I don't know where you are trying to get the question, really. As I already answered you, there is everybody knows that we are not allowed to do cryptocurrency. Myself and staff and everybody, any staff joins, they know. But we don't even tell them, oh, listen, when you join as an investment manager, you don't do cryptocurrency, but because it's not allowed in the whole country. Basically, it's not allowed in the whole country for regulated firms.
On day 5 of this trial, at page 81, lines 4 to 18 of the transcript, you don't need to go there. I can read you the question my learned friend, Ms. Stewart, asked you. The question was, Ms. Stewart asked you, and so TABARAK does crypto-related asset management? Question mark. Your answer was, you're still referring to crypto. As I told you, we don't do anything related to crypto. And I have told you exactly. Sorry, I have explained to you earlier in our cross-examine your words in the morning what we have what we think about digital asset. It does not mean that it's cryptocurrency, even though digital asset, what we think is of anything digital, visual digital, PDF, presentation, leaflets, brochures, you can scan and send it to any other safe place. This is digital assets considered, end quotation. Surely you don't agree with that statement. You know what digital assets are. Cryptocurrencies are digital assets, or any kind of digital coin backed by a physical asset is a digital asset. Would you agree with that?
My answer was to the counsel that she asked me. I said, from my own understanding, digital as cryptocurrency is not considered as a digital asset. That is my answer basically to her.
But digital asset can be a currency, a digital currency, correct?
I don't know that really. That's what, from my understanding, I answered very clearly to the counsel previously.
You would agree that gold-backed digital asset like a nefarious coin would be a digital asset, correct?
Still, you're referring as a cryptocurrency or what exactly?
No, I'm saying for example, a gold-backed digital asset or a digital coin like nefarious coin that you were seeking to bring to market, that would be a digital asset, correct?
I don't know if you will define it as a digital asset. I don't know really.
Can I ask you to turn to 817, please? Are you there?
Yes, I'm here.
So this is part of the presentation, what you call the white paper on nefarious coin. And at number 5, it talks about, sorry, excuse me, I've got a alarm here, just one second. Sorry, I apologize, there was a security alarm. So at number 5, patents and trademark rights. It says currently the following copyright, patent and trademark rights for Tabarak Investment Capital are available at. It gives your DIFC, I think, registration details, and then it says this coin was trademarked with registered with number 605344. Correct?
No, that's nothing to do. This number has got nothing to do with the Tabarak registration and DIFC. This is the people of Necros. They created this. It's got nothing to do with us. It's not even registered in our trademark and license or DIFC website. This is unknown to us. This number, registration number.
So, are you saying that you're not aware of this coin being trademarked?
No, I was not aware.
Would you consider the nefarious coin to be a digital asset?
As I said, you keep repeating the same question. Digital asset, in my own understanding, can be anything except cryptocurrency. From my own understanding, what people think about it is a different story. Nucleus idea was not. I don't know. I cannot define it as a digital asset or what. I don't really. I cannot tell you anything about it. But all I know that if this product has been established, it was going to be backed by real asset, which is our gold reserve sukuk. And beside that, I have explained also before that was a proposal came from a party in Europe to us. All this white paper has been established without our approval. We didn't even know about it. All what we know, they put it on their website with some, even you're telling me about this number with their own. That's why I interfere here and I terminated the idea of continuing with them. Because in the beginning, they did something wrong without our approval. So we said that's it, finish with them. There was, as I mentioned earlier, we are always open to listen to ideas. If a digital asset, as you mentioned, like Necros coin came and they want to backed by our gold reserve sukuk, which is real asset backed, physical real asset gold, we might look into it, see how we can work on it, and then when we are happy, everything is agreed, we will approach our regulator. We say, listen, our DFSA, we have this, what do you think? So always, before even we market anything, we even go an issue, we have to take final approval from our regulator. So this idea did not even materialize to reach to this level. We just cut it off because they started writing things without our approval, without our knowledge. That's why this idea got, we canceled it, we killed it.
Okay. Can I take you to 8472, please?
847. It's not here. Yes, I'm here.
So this is an email from Mr. Turner using his Tabarak email to Ms. Zoe Liu of HUOBI Global, and amongst others who are copied here are Mr. Al-Ali, Mrs. Saxena, Anastasia Zavilova, yourself, and Mr. Abdul Qadir Khan. And this and the subject is request of KYC doc and info for HUOBI account, Tabarak Investment Capital Limited. The date of this email is 22nd January 2020, correct?
Yes, I can see it, yeah.
And you can see Mr. Turner is writing, and he's talking about, that he's confirming that Tabarak does not trade anything with you, and then talks about,
It's confirming that Tabarak does not do anything related to.
No, it says we are not trading anything with you, so they're not trading anything with HUOBI. Correct?
What you meant by that?
Because that's what, if I read you the sentence, Mr. Turner writes, you need to know that we are only on service for HUOBI, and we are not trading anything with you. Correct? You agree with that?
We can see what that says.
Yes. Sorry, I'm just trying to basically get his attention on this, my lord.
On the same page, I can see the wording, no problem.
And then he reiterates and says, board resolution, we don't do anything related to crypto, we only do digital asset management. Correct? And when you read this, what did you think of this digital asset management, that Tabarak does digital asset management?
I told you what my understanding of digital asset management already. I don't need to repeat that and waste your time and the court's time. I've already answered the council as well last week about it. It is all related that, for my understanding to that email was HUOBI's opening account with Tabarak, missing documents, whatever it is, because sometimes when some corporates, if they want to open account with us, they also ask for our KYC as well. They want to see who we are and everything. So that's why he provided them with the shareholders' details and everything. At the end of the day, HUOBI was not a client of us. Until now, HUOBI was not a client. So it was still discussion, for my opinion, discussion between one of my senior staff with HUOBI to still complete or finalize their onboarding procedure to be a proper client to Tabarak.
But you would agree that in this email, it's quite clear that digital asset management concerns crypto assets, correct?
As I told you, I don't understand. I did not, from my understanding, digital assets, from my understanding, does not include crypto. I explained to you earlier, and you mentioned that. What's my understanding of the digital assets?
Well,
you mentioned earlier before, anything could be digital assets, could be an application, could be documents, presentation, leaflets, audio visual, voice visual. This is all digital assets from my understanding. And you keep
Mr.
repeating.
Matthew, I'm sorry to interrupt you, Dr. Ahmadi. Mr. Matthew, I think we've reached the point where it's a matter of submission from here in as to this question, as to whether, first of all, the broad question that you started with, as to whether there was any prohibition against dealing in cryptocurrency or crypto assets. And then the next question is, well, what is the witness's understanding of what a crypto asset is? I think we're going to, the witness will repeat himself in the way in which we've heard not only today, but at the last day's hearing. And it's, I want to assure you that it's open to you to make submissions, enclosing submissions on documents such as this, on this issue. So what I respectfully suggest is that you move on to another topic.
Thank you, my lord. I will move on. Dr. Ahmadi, isn't it right that you introduced Mr. Turner to Mr. Rudolph and Mr. Morozov?
Absolutely not correct.
Have you ever met Mr. Rudolph?
I met him once in the office, Mr. Rudolph, briefly. Of course, you know, when I got to know, when I was introduced to Morozov, that is way back, yes.
When were you introduced to Mr. Morozov?
Morozov was introduced early 2020, I believe. Early January, maybe. I think January.
And did Mr. Morozov introduce you to Mr. Rudolph?
I think they came to the office together with Christian, with Mr. Turner.
At paragraph 42 of your first witness statement, which is 671, you state that you had not seen the account opening agreement between the claimant and TABARAK until after the Bitcoin transaction on 3rd February 2020, correct?
Which section, this one, please? Which
paragraph 42.
42?
Of your first witness statement, which is at 671.
Yes, yes. Yes, I haven't. Yes, I haven't seen it. Yes.
So you had not seen that. So if can I take you to 894, please?
Yes, I'm here.
This is an email from Ms. Zavilova to Mr. Al-Ali, copying Mr. Turner and attaching the asset management agreement and the account opening agreement. And if you can move forward and come to page 899.
Yes.
You see that Mr. Turner has signed the agreement, correct?
Yes.
And then there is a seal next to his signature.
Yes, I can see it.
You would agree that this is the identical seal to the seal that we saw on Mr. Turner's employment agreement, correct?
Yeah, this is our seal, yes.
And this is the same seal on your articles of association as well, correct?
Yeah, if it is the same one, yes, it's correct, yes.
So you must have sealed this agreement next to Mr. Turner's signature, correct?
No, I haven't seen it.
No, I'm saying you must have sealed, you must have put this seal on this agreement, correct?
I haven't put the seal, no.
Dr. Ahmadi, on day 5 of this trial, at pages 149 and 150, we discussed the possession of the seal. So I asked you, so let's say if it's an agreement from TABARAK, an account opening agreement, who would normally seal that? You answered as follows. Account opening agreement, of course, as I say, we only have 3 people that have the seal. So then I asked, so any of the 3 people could seal an account opening agreement? It's possible, yes, you say. But as I said, they will only do it on my permission. And if it comes with account opening agreement, because account opening agreement only must be signed by me. So then I asked you to clarify this point. So account opening agreement would only be sealed once you authorize it, correct? You said, yes, exactly.
Yes. Yes, that's correct.
So I ask you again, at page 899, there's a seal next to Mr. Turner's signature. You
Yes,
must have sealed this.
No, it's not me. I haven't sealed it. See, I know where you're getting, Mr. Salah. You want to just say that since it's been sealed means I give the approval of the account opening. It didn't happen. And you asked me who has the seal, and I named for you 3 people, and you know them very well. See, with these people, the seals are not hidden in the safe or anything. These people, when they come and they put the seal on their desk, it is there. They use it for their own duties when they have to sign, when they have to seal any documents. Either some documents need my approval, like account opening definitely need my approval. Some documents, they don't need my approval, like any normal documents, nothing to do with account opening or anything. So where did he get the seal from? This is your question. I know you want to ask me where did he get the seals from? That is, I cannot answer you because there are 3 people, they have the seal, myself, and I mentioned the name. He could get it easy because he can even go to any desk to see the seal and stamp it. Besides, he had good relation with the finance officer. They were very good friends during.
Wait a minute, something's gone wrong.
Ask him for
I'm sorry, Dr. Ahmadi, I'm afraid we lost you over about the last minute. You had explained that the seals are in the possession of the 3 named people, and the thrust of your evidence was that they were in effect available to members of the staff so that they could seal things that didn't require your approval. And the thrust of your evidence is that this seal on this document could have gone on to the document without your approval because the seal was accessible, and in the manner that you've explained. I think I summarized your evidence correctly. Do you agree?
Your Honor, I'm not accusing, I don't want to accuse that Mr. Turner, he went behind the staff back and took the seal from their office and stamped the contract. I confirm to Mr. Salah, I don't know about this account opening agreement. Definitely is not me who authorized the seal. How he got the seal, as I said, from the understanding, Your Honor, what I can see is he had some relationship with the person who holds the seal there in the office. And maybe he asked him for a seal. If Dr. Ahmadi was not there, please stamp it for me. He got the stamp. This is possible. But I cannot presume or say where exactly he got the seal from. It is
right.
Yes.
Thank you.
Yes.
Yes, thank you very much. Well, we've got that. Yes, Mr. Matthew, do go on.
Thank you, my lord. I want to basically further, clarify this point, because when I asked you, do you have any protocols how these 3 individuals, including yourself, use the seal? At page 50, you answered as follows. Besides me, sometimes there are some documents needs to go out from finance department with seal. For instance, like invoices or other things. So we have to seal to seal it. It depends on the documents we are sending out. So it's from your testimony, Mr. Khan would have only sealed a invoice or a finance related document, correct?
This is what you are thinking. Maybe he convinced Mr. Khan to seal it for him. Everything is possible. Since they had good relationship with each other, everything is possible. I don't want to accuse anybody. This is one of the possibilities. Because one, I will ask you and answer you again. I didn't know anything about this year. I'm not the one who sealed that contract. So then it's up to you to think about it.
Dr. Ahmadi, I'll put to you that this is an account opening agreement.
Yes.
And in accordance with your own testimony, only you could have sealed it and you could have authorized sealing it. So it is fair to conclude that you must have sealed this.
No, I keep repeating it. It's not me who sealed it. See, Salah, one thing. Had I known that about the account opening agreement, the draft is done. I've seen it or been sent to my email, which has not been sent to my email, and they wanted to seal it immediately, I would ask the staff, okay, I will instruct one of my staff who have the seal, please seal it on my behalf. However, sealing it in my behalf means it has to carry my signature because account opening agreement, I have to sign it. So this account opening agreement has the sealing of the company and the signature of Mr. Turner.
Yes, well, let's move on, Mr.
Yes.
Matthew.
Yes, my lord. It's correct to say that you were aware of the Bitcoin transaction between the claimant and the buyer sometime in December and on 3rd February 2020, correct?
See, you're referring to some particular email?
I can take you to I can take you to a series of emails to show your understanding.
You refer to
Yes. So can I take you to 8316, please?
It's here. Yes, I'm here.
This is an email from Mr. Turner, and it's dated 20th of December 2019. And your copy to this email, it's an email to HUOBI and to Mr. Morozov. And you can see the content of this email. They're discussing a Bitcoin transaction. And it's correct to state that your copy to this email, and you must have seen this email on or around 20th of December, correct?
Probably, I don't remember, but I already answered this email to the last week. There was a lot of emails being exchanged between my staff and his prospects. It doesn't mean I need to interfere at this moment, because at this moment there's only prospect, not becoming client. Had HUOBI client, real client, onboarded officially, and this email came, then I will go to ask Mr. Turner what you're talking about. Email has been exchanged all around all this period. At the end of the day, the discussion going on between my staff and the prospect discussion, they are talking about it. But had I will agree to onboard them to do a cryptocurrency transaction, definitely not. As I mentioned earlier, also, I would like to explain, if you allow me, Your Honor. The reason why I was told HUOBI will come as a client, they have other businesses besides Bitcoin. That's why I said, okay, continue with them, negotiate as per our policy, bring them on board. It's not a problem. They deal with real estate, they deal with, as I explained earlier before last week in my statement. So it's not that they are dealing with cryptocurrency that we cannot take them as client. We can take them if they are not doing cryptocurrency transaction. They are normal company, registered in DMCC, local company. But then negotiating, given procedure that they are talking like 20 emails every day, maybe.
Well, Dr. Ahmadi, let me ask you this, please. Did you read this email when it arrived in your inbox? Or wait a minute, or shortly after it arrived? Did you read it?
I don't remember, Your Honor. I don't want to give precise answer. I don't really remember if I read it or not.
Thank you.
Again, I've got a short question on the next page. If you turn to next page, 317. Again, my question, Dr. Ahmadi, is that this is an email from HUOBI's Mr. Saxena to Mr. Turner, Mr. Al-Ali, and Mr. Morozov. And amongst others, you're copied to this email as well. And again, they're talking about, in the subject line, new BTC wallet address, according to today's meeting at TABARAK offices, handling process. It's dated 22nd of December. You must have seen it. It's not a long email. It must have come across you at that time, correct?
It is the same thing as the other email. My answer will be the same thing as the other email. Yes.
Okay. Following on, if I take you to page 819.
819.
It's an email again from Mr. Saxena of HUOBI, and you're copying.
About which 819? I have different.
Sorry, 8319. I apologize.
Yes, I can see it. Yes.
So again, this is an email on the same day, 22nd December, from Mr. Saxena to Mr. Turner, Mr. Al-Ali, Mr. Morozov, and you're copied to this email. And in this email, they're asking that they're trying to arrange 0.00125 BTC to the wallet address provided. So it seemed like they were at this stage they were talking about there were advanced discussions on this, and you were copied to this. This must have raised some alarm in you, because you have reiterated so many times in your testimony that cryptocurrency and crypto transactions are banned. So this must have given you some alarm, correct?
As I told you, this is the same continuation of their discussion with the previous email that you showed me. The same continuation, discussion ongoing and ongoing. It's not as I said, it's not the first or second email. That's why my interference in this is not necessary, because HUOBI is not a client yet. So they can discuss anything they want, but they cannot do anything. You cannot provide the services to HUOBI. First of all, they are not client yet.
But Dr. Ahmadi, you would agree that even if HUOBI is a client, you can't do this, right? Isn't that right?
Yes, I agree that. Yes, definitely.
So in any event, you should have intervened and said, we cannot do this, correct?
See, Mr. Salah, as I told you, that is ongoing negotiations, discussion between one of my staff and his prospect clients. Many emails flying around every day, emails flying around. Doesn't mean I have to go on everything and dig on every single word. I have to interfere. At this moment, my interference was not necessary, because it's a discussion going on between a prospect and TABARAK. That's what I can answer you. There is nothing that we cannot, even if they agree on between themselves, it will not be agreed finally by me, which is the decision maker of any transaction.
But could I ask you the same question on this document as the previous one? Did you read this document after it had come into your inbox?
Your Honor, I don't remember, to be honest with you. This is my real question, my real answer, I mean, sorry.
I see.
My honest answer, I don't remember.
Dr. Ahmadi, you would agree that you are the CEO of this company, and all this business development is happening on behalf of your company. These are serious transactions, and there must be a compliance policy that management must read their emails, correct?
This has nothing to do with business development. This is only a basic discussion between one of my staff and a prospect. It's nothing to do. You talk about business development when the client become onboarded officially. Yes, here we can talk about business development, business, whatever, marketing and providing services.
Okay, Dr. Ahmadi, please can I take you to 8421.
Yes.
So now we have reached 19th of January 2020. And this is an email from Mr. Turner to Mr. Saxena, Mr. Al-Ali, Mr. Shahib, and Mr. Morozov. And you are copied to this email, including Ms. Zavilova and Mr. Khan. Now, at this stage, they are now talking about final procedure to start business. Mr. Turner is setting out discussions between the buyer, based on the discussions between the buyer and the claimant, and he's setting out an elaborate procedure that's agreed by the parties. And at this stage, you must have read this email, isn't that right?
Yeah, probably I read it. And also I talked to Mr. Turner as well about it. I said, what's going on? He assured me, said, no, nothing, don't worry, everything will be okay. We are just doing, this is only procedure. We got, nothing will happen. HUOBI will come. Because I told him, I said, how come you're providing this to non-client of us? And, you know, we cannot provide this type of services. He again calmed me down, said, no, don't worry. Nothing will be done under TABARAK. Nothing will be done without TABARAK license activities and everything. So as usual, whenever I jump in and ask him, he calms me down, gives me millions of excuses. But at the end of the day, I was not worried because none of the services will be provided to the client without even becoming client of us. So it's all as the same thing as the previous emails, discussion, negotiation with HUOBI and Morozov and whoever it is. It's still the same thing. Same his discussion. But at the end of the day, have we agreed, TABARAK agreed officially to provide the services to these parties? No. Did I agree officially? No. Why should we go and agree for a client that they are not client of TABARAK? We cannot even discuss about providing services. So all this type of things that is done by Christian Turner, when I confront him, he always calm me down. Don't worry, we will not do anything, nothing will harm TABARAK, this and this. He knows I'm very strict with that. He knows very well. He knows very well I will not provide any services to non-client. He knows very well we don't deal with crypto.
Dr. Ahmadi, you know, TABARAK was a very small organization. After you received this email, which you said that you read, and then you had a discussion with, you alleged that you had a discussion with Mr. Turner.
I said I probably read it.
Probably read. Okay, probably read. But then, because you probably read this, that's why you had a discussion with Mr. Turner, right? You must have spoken to your director of compliance saying, you know, Mr. Aziz, this has come to my knowledge. Did you?
This compliance officer will not be involved himself into this type of things. This is not a compliance, because compliance will only jump in if it is one of our clients doing this. Compliance is a way out of this question, out of this procedure.
So normally, business will not talk to compliance on daily basis. Is that what you're saying?
Compliance does not communicate with clients.
So what does compliance do in TABARAK? Can you give us some understanding of that?
See, Mr. Salah, I think that you know the answer very well, but I will say it for you. You just want to hear if I make any mistakes. Compliance, we have HUOBI, they want to come, or Mr. Salah wants to come a client with us. The RM comes and provide the Mr. Prospect, this is what documents we need, this is what we need from you. Then the RM job is to take it to compliance. It said, Mr. Compliance, we have this prospect, please do full compliance on this person or company. This is where the compliance will come involved. Then once everything is okay, compliance got, then the client will not be onboarded without the compliance approval. And beside other procedure, paying account opening fee and all this thing, providing all the necessary documents. So compliance is like any compliance of any regulated firm.
Okay. Dr. Ahmadi, can I take you to 8422?
one more, the compliance makes sure that the RM adheres to our rules and regulation by providing the correct documents.
Okay. Please, can I take you to 8422?
Yes, I'm here.
So this is again an email from Mr. Turner to the to HUOBI, and you're copied to this email. And this email again is from 19th of January, and they're again talking about request for first transaction of 1,000 digital asset, BTC, which means Bitcoin, first order for 1,000 pieces of BTC. Surely you must have read this and said to yourself, what is this? Correct?
This is the same, yeah. This is the same scenario when I confronted Mr. Turner. I told him, what is this? Same thing. He said, nothing to worry. That's nothing to do with the TABARAK. This is this is that. The same thing, the same scenario. Because I remember this very well. Mr. Turner doesn't sit far away from me. I can always walk to his office and speak to him about anything. So every time something like that I read, I go and talk to him. I say, listen, we cannot do that. We cannot. He always assure me again, yes, don't worry, we will only comply with our rules and regulations. So I consider this the same email as the previous emails correspondence that he was exchanging with other parties.
Dr. Ahmad, you'll agree that by this date and in this email, you must have recognized that Bitcoin is a digital asset because Mr. Turner is talking about providing digital asset services, correct?
Still, digital, as I told you, my understanding of digital assets still doesn't change. I don't know if cryptocurrency is digital assets, consider one of it or no, I don't know.
Okay.
As I told you, my understanding about digital assets, so I think I don't need to repeat myself.
And can I now take you to 8484? 8484.
Yes.
So now we are at January 27th. And this is an email from you to Mr. Turner. And this is on the back of email from Mr. Turner to you. On the next page, you can go there first. It's 8485. This is an email from Mr. Turner to you. He's copying Mr. Khan and Ms. Zaviolova. And he's writing to you, dear Mohammed, this is all about testing, because I think you had raised the question of what was happening with HUOBI. And he said, this is, and he writes to you, this is all about testing session we received, and now we transfer. When I'm back, I have a meeting with them, and then we also have the account opening fee, okay? And then at the back of this, if you go back to 8484, you say as follows. You don't show any, the only in this email, isn't it right? You are fine with doing additional asset services, provide digital asset services, but you don't want it to be mentioned anywhere, correct?
No, it's not like that.
Because Dr. Ahmadi, you say this.
You see, if you see, this is where I interfere personally. If you see my email addressed to Christian, I address to him Christian only without dear. It means he knows that I'm upset with something. Okay, this is one point. Secondly, then, if you see for 48485, I told him that how come you're providing services to HUOBI without becoming a client? And then, of course, the usual thing, he started to wind me down, this and that, and already did the testing, already did that. That's where I said, how do you do the testing? I was against doing it, but he did it without my approval, without my willingness to allow him to do it. And then this is 27 January. This is where I really interfere personally, where on 28, I stopped everything. I stopped completely. I told him no more stop it. This has gone way out of the line with you. Stop it. We are not going to provide any services to HUOBI. We don't want them as a client. We don't want anything to do. So then, of course, he informed them that Tabarak does not want to do any business with you. So this is where I put an end for everything, because I realize it's going nowhere with one of my senior staff.
Dr. Ahmadi, I want to ask you a few more questions about this email. In this email, I don't see you saying to Mr. Turner that we should stop any business with HUOBI. Instead, what you're saying here is that you're mentioning, you're saying now they are sending funds and mentioning digital asset sale, which is not supposed to be mentioned in any transfer in whole UAE. They need to mention their account opening reference, and that's all. I mean, on any analysis, it doesn't show that you were concerned about doing this transaction. Only thing that you were concerned about was that they should not mention this anywhere.
No, he already proceeded with everything without my permission. He already proceeded. He already said, that's why, I mean, your continuation of this email, I was very angry. That's why I addressed it to him. Just Christian means he knows that I'm angry with that, whatever happened. So now he did things without my agreement or approval. It's okay. Then I explained to him, why did you do that without this? And so I said to him when I was really upset with him, said that's why next day morning I put an end for everything.
In respect of the
and I think you know that very well.
Well, Dr. Ahmadi, we're looking at this email. We can look at subsequent emails, but we're looking at this email. Now, please tell me, what did you mean to convey when you wrote they need to mention their account opening reference, and that's all?
Yeah, because he already, Your Honor, he already told me he already gave them the permission to transfer. So it was too late to stop it. So I was telling him, why you did this? At least if you did that, don't let them mention at least the reference that you provided them within the company. At least we know the money from whom it's coming. So that is all from my understanding of telling him that. At the end of the day, he already proceeded with everything.
Now, it's right too, isn't it, as I look at this email, that it says, it does not say that the proposed transaction must be abandoned because it concerns cryptocurrency. We're not authorized to deal in cryptocurrency, and therefore this proposed transaction must not go ahead. There's nothing of that nature in this email, is there?
Yeah, but next day I told him to stop everything, Your Honor. I canceled everything next day, 28 January. I said to stop everything because it's going way out of everything, and I got confused with what he's doing. I've got everything like messed up, so that's why I stopped everything 28 January. I stopped dealing with HUOBI. I told him not to do any more business with HUOBI, nothing at all, which he relayed this message to them. So,
well, I'm a little puzzled why you did not say what you said the following day when you wrote this email.
Your Honor, maybe I was confused. That's why I confused. He made me a lot of, big confusion things. That's why it didn't come maybe into my mind to say that to him. But deep inside, I know that I don't want this one to happen. He already created this line of the procedure with them or whatever. That's why next day I told him, that's it, finish. I don't want anything to be done with them.
Thank you. Go on, Mr. Matthew.
Thank you, my lord. Can I take you to the first two lines of this email? You say that we discussed this client in my office last time, and you mentioned
already, no?
Sorry?
We didn't discuss this email already, or you want?
Sorry,
no, the council is quite at liberty to continue to ask you questions about the email. This is a different point that he's proposing to make.
Okay,
or Mr. Matthew.
Thank you, my lord. You say in the first two lines of this email we discussed this client in my office last time, and you mentioned that they will do a trust transfer. And I didn't mention to you that they need to be a client and pay the account opening fee in order to do all the jobs for them. So isn't that right? You are not concerned about this client being a cryptocurrency oriented company or a digital assets company and seeking digital assets services from you. It seemed like you seem to be fine with this proposed engagement with HUOBI, correct?
No, what I meant by this, my email to him, to first two lines, is how come you're providing services? Client is not a client of us. I mean, even though when he become a client of us, I will not agree to do cryptocurrency with business with them. So it's me. I'm clear with him that you cannot discuss or even agree with them anything without becoming client and pay account opening fee and get the compliance go ahead and write us a letter of intent and everything as per the normal procedure. That is what I meant with these two lines.
In the end, you say that in regard to the two Bitcoin sold through HUOBI, you say what's our commission on this? So isn't it right? You were okay to take commission on sales of digital assets through your company?
No. He did this two test tranche. We discussed last week about it without even my permission. He said he even used TABARAK account without my consent. But then when he does this, okay, and then he discussed with me, I said, okay, now you did all this mistake. You used TABARAK account for your just 2 Bitcoin for your private company, OCS. Now all these things, are we gaining anything out of it? That's a question. Of course, we did not gain any single penny out of this transaction. So he used TABARAK account for his test. There is no anywhere that I allow him to use TABARAK account for this, but it's already been done.
At least at this stage, Dr. Ahmadi, you will agree that you knew what digital assets were in the context of crypto, because you mentioned them a number of times in this email.
But as I said, digital assets, still no.
Surely, Dr. Ahmadi, you're not discussing PDFs and PowerPoints.
No, I'm saying that, but you still keep repeating this. You're just thinking that I'll change my understanding of digital asset. This is my understanding of digital asset I mentioned to you earlier. For me, crypto is different than digital assets. So how you want to put it, I don't know, but this is my understanding. As I told you, I will agree to do digital asset business on what I understand, what we talked about it earlier.
Dr. Ahmadi, given the series of emails that I have showed you, in which you were copied, it's inconceivable to say that you did not know about the Bitcoin transaction and you didn't understand what HUOBI was seeking from TABARAK, and it's not really possible that you didn't understand the whole scope of services they were seeking. Isn't that right?
That is what they were discussing. That is the discussion among them. But will I allow to do that if they become a client of TABARAK? No, I will not allow that.
In light of these emails that I've shown you, I would suggest to you what you have written in paragraph 43 of your first witness statement, which is at 671, cannot be correct.
Well, let him have a chance to remind himself of what he said.
Yes, Dr. Ahmadi, please have a read of it.
Which paragraph, please?
Paragraph 43 at 671.
Where exactly you're referring?
If you can read the paragraph 43 in its entirety. Now,
yeah, okay. So it's still the same. I can see that I was copied with some email and not email, which is true. And then in Franklin's, I was not following what was being said to that email, all the email, which is true. First of all, Mr. Turner told me that HUOBI will deal in real estate, and I understand the relationship that they will build with us in property investment. I can see now clearly, Mr. the type of property transaction that HUOBI were engaging in, but at the tone I verbally discussed. So this is where I have put an end for everything. When I started to know now, he's talking with them deeply about cryptocurrency, or I don't know, whatever it is. So this is where I came and I said, finish it. From my understanding, when he asked me, I said, yeah, but why they are coming? Why they wanted to become client of TABARAK? He said they do a lot of business with property, and they deal with developers and everything. It's fine. We can accept that.
But Dr. Ahmadi, you would agree with me that none of the emails that I showed you talked about any property transactions, correct?
I don't know. I think so, yes. But property. I was told when he started negotiating with HUOBI.
No, I'm talking about the emails I showed you. None of those emails talked about any property transactions, correct?
That's correct. Yes.
And excuse me, Dr. Ahmadi. By 27th of January, you admitted that you understood what was going on. The last email that we at length discussed. So it can't be right that, between the 17th of December and 3rd February 2020, you did not know the nature of the services that HUOBI was seeking from TABARAK. Because you say that here you say only thing you knew about was some property transactions.
So this is why, okay, as I said in the beginning, when they wanted to onboard HUOBI, I know the nature of services they needed from us, which we can do as per our scope of license. Then when he started talking with them about cryptos, all the same, that's why I said we did not continue with them. I put an end for them for it. So there is nothing that we did anything for them, because the 28th January I closed the chapter with them. That's it, because Mr. Turner, he makes me confused. Every day he's telling me something, nothing to do with TABARAK. We do as well, we do this. We will only do as per our license. Then until such time, I realize I have to really put an end for it, which I did immediately after that.
Dr. Ahmadi, I'll move on. I think we have discussed this at length now. It's correct that at TABARAK, there's a culture of recording everything, all the agreements, all the documents in preserving all the documents in hard copy form, in client files physically. Isn't that right?
So what do you mean client's file? We have each client, we make file for them. Yes, normal.
It will be there will be a place in the cabinet where you will keep all the files, correct?
That's correct. Yes.
And it's accessible to everyone, including to you, correct?
Yeah, but you see, each RM, he has his own cupboards, he has his own shelf. He puts his client's file in his own office. It's not with everybody else.
But nobody locks their offices. I mean, you're a small organization. You can move into each other's.
No, we don't have doors in the offices, except meeting room and my room. Only there's doors. The rest is open, everyone office, but without a door, only partitions.
So you would agree that by this time, you would have seen the signed account opening agreement from that Mr. Turner sent to HUOBI, and HUOBI signing and sealing it, correct?
Which day you are talking exactly?
I think sometime before the transaction, to 20th of January.
Yeah, but still, as I said, Mr. Turner already signed and sealed, as I can see, signed and sealed the account opening agreement, and he sent it to HUOBI for signature. Still, I was not aware of that. Still, I did not see Only I saw it later when the you know things started, the case started. Because at the end of the day, I will know from compliance. He will tell me this is approved because compliance will copy me and every approved client said, okay, HUOBI approved, HUOBI not, and ABC approved, ABC not. So nothing sort of until now, until even when Mr. Or HUOBI signed the account opening agreement, they're still not a client because first of all, we didn't know anything about it. The compliance didn't know anything about it until now. The client did not pay account opening fee. The client did not provide all the documents that were required to become an official client. So it is something done just maybe between Mr. Turner and HUOBI. He can always put it in his file, it's fine, but we don't go and check every file unless we need something.
Okay, Dr. Ahmadi, I think we will not go any further with this, so I'll move on. You knew that Tabarak was wanting to open an account with HUOBI, isn't that right?
Yes, I knew that, yes.
And can I take you to 8371? So yes. This was an account opening with HUOBI, and your copy to this email from Mr. Turner to HUOBI. And Mr. Turner copies a number of documents to this email in regards to providing documents to open an account with HUOBI. So he provides them, as you can see on the next page, in the following pages, a copy of your passport, articles of Tabarak, which are basically also sealed, and then commercial license of Tabarak, Mr. Turner's passport, license from DFSA. Correct? Am I correct about this? I mean, right?
This is the document he sent.
Yeah. And then you will see that there's the Wolfsburg Group due diligence questionnaire. Do you know what Wolfsburg Group questionnaire is, Dr. Ahmadi?
This is something to do with compliance.
It's 8397.
8397.
So this is the last document attached to this email. Now the date of this email is 15th of January 2020, and your copy.
I am on 397, yes.
So have you seen this document before?
No, I haven't seen it. I've seen it only now.
So when this was copied to you, you never opened it?
Yes, I never opened it. Yes, it's true, yes. But and this normal, I don't know. Well,
so if I take you to the last page of this.
Yeah, I remember this email maybe probably because he's allowed to send a draft account opening agreement to people, to prospect, to look into it. As I mentioned earlier, some clients, they ask about they want to do due diligence on us before they become a client. So he can send this document, it's not a problem. The draft of account opening agreement. Of course,
so you would have had no problem with this agreement being sent over.
No,
right?
A draft agreement. They send the draft agreement always, but the draft agreement was our normal draft account opening agreement.
And what about this report? Do you see anything wrong in this report? Or, I mean, if I take you to the last page at 8413.
397.
8413, which is the declaration statement of this report.
8413.
413. Yeah, I can see that, yes.
You can see Mr. Turner has signed this on 10th of July, and Mr. Malik has signed this as well.
Well, see, this definitely signed by Mr. Turner, but it's not signed by our compliance,
Sorry, not signed by?
by Mr. Malik,
How would you know that?
because I know.
So
He
whose
will-
signature is this?
Mr. Malik is a witness. You will question him later on about that.
Well, do you recognize what appears in handwriting next to signature and date below where Mr. Turner signed?
Yeah,
There's
that's,
a sort of a squiggle. Do you recognize that as a signature of anybody?
no, I don't recognize signature of anybody. I can see just some line up and down only, like a zigzag. But yes, I don't recognize it.
But you would agree that, Dr. Ahmadi, that Mr. Turner will not attach a document, copy you, if this document was not authentic, correct?
Yeah, but see, this is, as I said, he sent the HUOBI might have asked some documents for them to do due diligence on us, and he filled up this questionnaire and he sent it. So this is normal because sometimes clients they ask to do due diligence on Tabarak. They want to see we are real, we are that. So Mr. Turner, I'm sure he attached. See, being Mr. Salah, it's one thing you need to remember as well. Mr. Turner is senior manager, okay, of Tabarak. Used to be senior manager. Means I put a lot of trust on him and what he does. It is not my. It will be not nice for me to check every single email he sent because he knows his duties very well. He knows what he has to do. He knows what he has not to do. So it's not for me fair to go every single email he sent. I check everything because he knows his duties. He knows as per his job description what he has to do. It will be unfair for me to check everything. It means I don't trust him. So this is normal negotiation. The same thing is sending the draft, our draft opening agreement to prospect. They send the documents on about Tabarak, about shareholders. He filled up this documentation. He sent it, but I'm sure the signature is for his, but the second signature definitely first time I see it.
But Dr. Ahmadi, you would agree that if this was a forgery, it's a very, very serious allegation, correct?
If it was a forgery, of course, it's a serious allegation.
But isn't that what Mr. Aziz is alleging at paragraph 40 of his first witness statement, which is at 699?
Yes, I'm here, Mr. Salah.
So if you read this paragraph 40 for me, it's a short paragraph, and then we can have a brief discussion. Paragraph 40 is talking about this document.
Ask me to read it, right? To read it quietly. I'm reading it. I'm not sorry, I'm not too fast as you in English language, but bear with me, please.
Sure.
Yes, I read that, yes.
And you would agree that this is a very serious allegation.
It is, yes, of course. It is a serious allegation. I don't say no.
And when you realized this had happened, surely you must have said, we need to report this, correct?
No, I only saw this when I only saw this, even Aziz, he only saw that when the case started. You know, we did not see it only when the case went in the front of the IFC courts.
Dr. Ahmadi, forgive me for repeating this. You are a private banker have a distinguished career, have hands-on, working style. It would be inconceivable to think that you would not see this questionnaire and think what exactly is in this questionnaire. when this was emailed?
Mr. Salah, I probably even did not see the whole email because I trust my staff. I trust what my senior staff. Why he's sending documents to the other parties for them to do due diligence. So you think, just think about it. If we knew, myself and Aziz, at that time when he sent the email, that this document has been signed on behalf of compliance department, which is not his signature, definitely we will. That then he will be questioned. But as I said, he sends a lot of email every day. I cannot just go and see every single document and see all the pages and everything because we trust the stuff.
Dr. Ahmadi, when the 3rd of February 2020 incident happened, surely you said that you investigated the matter with Mr. Aziz and Ms. Fuladi. I'm sure at that time you must have looked at all the emails and all the documents concerning Mr. Turner's involvement with HUOBI. So at that stage, it's inconceivable for me that you would not have seen this email or reviewed this agreement after that incident, because what you've told us that this is the first time you've seen this document today. Isn't that right?
Not today. Salah, why you are misleading my words? I said when the trial started and when the case went in the front of the IC courts. Why you are saying different things? This is exactly what I said.
Well, earlier in your testimony, Dr. Ahmadi, I must point out to you that you did say this was the first time that you had seen it, and then later on you have you've told the court that it was when the proceedings got underway in the DIFC court that this document emerged. So Mr. Matu was entitled to put that point to you, and I understand your response to be, well, it was during the proceedings, once they had got underway in the DIFC court, that this document emerged. Have I got that right?
Yes, exactly. That's why I was telling Mr. Salah that I don't mean I see it just today, this morning. As I said, I didn't check all the documents that have been sent through Mr. Turner's email.
Go on, Mr. Matu.
Thank you, my lord. I think I'll move on now.
I think I was talking about something. No.
Sorry, Dr. Ahmadi, please go ahead.
Yeah. So yeah, that is exactly as when I said first time. I don't mean first time today. First time when things the case emerged. Then of course, like any other party, you go and then later on you go and find out many things. Yeah. Okay. Go ahead, please. So.
Dr. Ahmadi, you'll agree that everything Mr. Turner was doing during his employment with TABARAK he was doing everything for the benefit of TABARAK, correct?
Exactly, yes. Well, that's what his duties are.
And he was not doing anything for his personal gain or for his personal self, correct?
Yeah, I cannot answer you that because staff as a person could have been, while he's employee with the company, he could be doing some other personal, some job for a personal benefit, which how do we know about it until something emerged? So there are, definitely as per his duties, he should only work for the benefit of TABARAK because he's employed with TABARAK. What he was doing, maybe he was doing some job in personal effect, I cannot say yes or no.
But whenever he was representing TABARAK, when I say whenever Mr. Turner was representing TABARAK, everything he was doing was in the name of TABARAK and for the benefit of TABARAK, i.e. any fees that any transactions he was trying to get for TABARAK would be for the benefit of TABARAK, correct?
Yeah, if any transaction that as per normal transaction, normal clients, yes, of course, we will benefit, he will benefit as well.
And this was the same position when it came to the Bitcoin transaction with HUOBI. Mr. Turner was doing this transaction because TABARAK would benefit from it. It was TABARAK's transaction that it was a transaction he was carrying on for TABARAK, correct?
Perhaps not, because you see, he was doing 2 Bitcoin as a test for his own benefit. So he used TABARAK only. So
But
here's the bill as well. If Mr. Turner was really 100% doing only business for Tabarak, I don't know, because definitely I will not be put on something that he's doing personally for something. He will be doing behind our back. Maybe everything is possible.
Dr. Ahmadi, I just a few more questions, and if I can take you to 8367.
Okay, sure. Second.
Let me know when you're there.
Yeah, second only. Yes, 8367.
So this is an email from Mr. Turner to HUOBI. HUOBI's Mr. Saxena and Mr. Al-Ali, copying Anastasia Zavilova and Mr. Khan. And you will see here, he is discussing the testing session for the Bitcoin transaction. And you will see that he has attached bank account details. And if you turn the page to 8368 and onwards, you will see details of 3 bank accounts, Noor Bank account details. And you would agree that each one of them has a reference of HUOBI FX asset management, and you will see that this is the Tabarak bank account, correct?
Yeah, I can confirm to you this is Tabarak bank account. But see, on this email and particularly, I was not copied. Okay, so he provided things he shouldn't be providing because HUOBI did not. Usually, when the client is on board, then we provide the account details, our account details with Noor Bank. And then when they need to do any transfer, we give them our local reference in-house. So he went and provided our account details with Noor Bank. We usually have 3 currencies, dirhams, US dollar, euro. It's normal, our account details, and he provided it with them, even though they are not client.
Dr. Ahmadi, you would agree that Mr. Turner did not provide his personal bank account details, correct?
This one, no, this definitely Tabarak. Yes.
That's my point. So if we move on to 8,
even though, sorry, Salah, even if he wants to provide his personal bank details, he will not copy Abdul Ghadir Khan and all these things. He will give them, or he will send it from his personal email account as well.
Okay. Now, can we go see 8419, please?
Yes, I can see it.
So this is the email from Mr. Turner to HUOBI's Mr. Saxena, Mr. Al-Ali, and Mr. Shahib. Again, copying one of your directors, Mr. Khan and Ms. Zabilova. This is dated 17th of January 2020. And forgive me, excuse me. And this attaches addendum to account opening agreement. Now, you would agree that none of the additional terms and fees that are mentioned in the addendum were for the personal benefit of Mr. Turner, correct?
At this moment, as I see, if the addendum has been attached to the email, yes, it is basically says Tabarak.
Tabarak, correct. Correct? Yes?
Yes, it basically says Tabarak. But at the end of the day, he sent it attached with Tabarak, his email account, Tabarak. So it is meant to be Tabarak. You see here, even I was not even copied on this email.
And can I ask you to please turn to page 455?
Is that 8455?
Sorry, forgive me, my lord, 8455.
Thank you.
Yes, I am on this page.
Again, this is an email from Ms. Zavilova to Mr. Shahid, who was helping with the Bitcoin transaction. and setting up the account for them. And again, Ms. Zabilova provides Christian's card as an attachment if you see the next few pages, and emails and sends the Tabarak bank account details that we have seen. So again, this is another, you would agree that this is another example that Mr. Turner and Ms. Zabilova, who's assisting Mr. Turner, was providing, was at all times doing things that will benefit Tabarak, and BTC transaction was essentially financially going to be beneficial for Tabarak, correct?
No, it's not correct. You know what actually is good is raised now a question here. I wonder why Mr. Turner attached his UAE ID card for a proposed client. We don't do that. It's not in our procedure. UAE personal ID card, attach it from his personal assistant to HUOBI about the account opening, account reference number, attaching his UAE ID card personal. We've never done that. We don't do it because this is now contradictory what you are saying. You're saying he's never doing personal business. I would told you perhaps yes, perhaps no. Now his secretary or assistant sending our account details with his personal ID, UAE ID. For what reason? There's no need. We are Tabarak. We are not Christian Turner. It shouldn't be happen that way. So this raised question mark as well here. Why he sent his personal ID card, UAE ID card? It's a private property.
Firstly, Dr. Ahmadi, it was not Mr. Turner who sent the ID card, it was Ms. Zabilova.
Yeah, that was his assistant. She will only do after his inspection. And
it's possible that maybe HUOBI asked for it.
I don't think so. They asked for personal stuff. Never happened. In whole my career of working, anybody asked, for instance, you are a client of ours, you asked Tabarak to send your account details. I am your RM. You said, okay, Dr. Ahmadi, can you send your personal ID card or passport? This is out of question. Never happened.
In fact, this is exactly what happened, Dr. Ahmadi, because if you read the email at 8455, Ms. Zabilova writes, Dear Ismail, third line, she says, please find attached requested documents.
Yeah, this is exactly what happened. I mean, why she's sending, or he asked her to send his personal ID card? For what reason? Cannot be, because this is first time happened to us.
It's not my big point, but the point here is that they were sending documents that were being requested by them, and we don't. The issue of their KYC is not an issue in trial. So I'm going to move.
HUOBI requested the ID card of Mr. Turner. You said that, right? HUOBI requested ID card of Mr. Turner.
That's what the email says. That's right.
Doesn't say anything here. Please send your personal ID card. So you just assuming something from yourself. There is nothing says.
I think really this is very much in the margin.
Yes.
The fact that this card was sent is not a sufficient foundation for any allegation that Mr. Turner was acting on his own behalf from a financial point of view when he was negotiating what the transaction that happened on the 3rd of February. So I think we'll move on.
Yeah.
I have one comment on that. Usually, most probably, if somebody asks for an ID card of an employee of a firm he's working, they will ask for a copy of his business card.
Well, you've heard what I said, Dr. Ahmadi. I think that this is not sufficiently relevant, not at the center of what I have to decide. The fact that this ID card was sent apparently at the request of HUOBI. So next question, please.
Thank you, my lord. Can I take you to page 8492, Dr. Ahmadi?
Yes, I'm here.
Dr. Ahmadi, This is an invoice dated 29th of January 2020, correct?
Yes.
And this is a invoice to HUOBI OTC DMCC, correct?
Yes, it is. Yes.
And it's an invoice payable to TABARAK's bank account, correct?
Yes.
And there's a seal, which I presume, based on your testimony, Mr. Khan must have sealed this, correct?
This is not a seal. This is only our tax reference number.
Okay. It's some kind of a tax reference seal, correct?
Yeah, tax reference, because we have every is for incoming invoices, outgoing. The parties must mention their tax reference number.
Do you seal?
I think really the accurate name for this is that it's a stamp. It's not a
Stamp,
company.
sorry, yes.
It's a stamp which allows the number to be used very easily and efficiently because it's on the stamp and you stamp the document.
Yes, correct, Your Honor.
Yes.
Were you aware of this invoice, Dr. Ahmadi?
I was aware, I don't know, but I have seen that, and I am aware that invoice has been sent to HUOBI to pay the account opening fee. That is, I'm aware. It's not, I'm not telling you that I'm aware it's been sent that, but so my discussion with Mr. Turner, because why I keep asking why they didn't pay the account opening fee, why they didn't open the account opening fee, even though despite we send them the invoice, they still didn't pay the account opening.
So just for clarification, on 29th of January, you were aware that this invoice was issued, correct?
It was issued, yeah, 29 January, yes, it was issued without my consent even, because 28 January, I have already terminated the relationship.
Okay, I'll move on now, Dr. Ahmadi. I've got a few questions on the transaction. You were aware that that BTC transaction was going to take place on the 3rd of February at Tabarak offices, correct?
You mean before the meeting or after the meeting?
Let's see.
See, I was not aware there was going to be a meeting. And the same day in the morning, Mr. Turner came to me and asked if we can use the buyer and the seller, because now since we don't have any relationship to do with the buyer or the seller, Mr. HUOBI, Mr. Turner came and asked me as a favor. He said, you know, can we use the office of Tabarak for their transaction? Yes, I was aware there was Bitcoin transaction, but however, I have discussed face-to-face with Mr. Turner. So Tabarak is not involved in that. Got nothing to do with that. They are not clients. He agreed with me fully on this. So he agreed that they will only use our offices to do their transaction. Yes, I'm aware that it was Bitcoin. That's why I made sure that Tabarak is not involved in that. Only they asked to use our premises, which I agreed as per request of Mr. Turner.
On 3rd of February 2020, you met the claimants, Mr. Saxena, Mr. Ali, and Mr. Morozov, and Mr. Sochin, correct?
Yeah, I met them that day in the morning. I said good morning because he asked me to come and say good morning to them. I did, yes.
Even though we know your position on this, Dr. Ahmadi, I'm still going to put our case to you that on behalf of Tabarak, isn't it correct that Dr. Ahmadi, agreed to the terms of BTC transaction with Mr. Ali?
No, I did not agree in any term with Mr. Ali. I did not even talk to him. I just came and said good morning, everybody, and that's when I went, just as a pleasantry only. Terms and this, I never discussed. They never discussed with me. Because I know they were just using our premises without involvement of Tabarak.
At the end of the BTC transaction, the buyer's treasury wallet was put in your safe at around 1:15 p.m., correct?
See, the buyer and the seller, including Mr. Turner, came to my office because my office is far away from the meeting. They were all, as I said, without prior notice. They came to my office. I was alone in the office. They came. buyer, seller, Mr. Turner, they came, they were very happy. They said they concluded the transaction, this and that. They congratulated me. I said, good luck. And then jointly, three of them, they asked me, doctor, can you keep this into your office? Which is, you know, they didn't, without even asking, they didn't ask me what's inside, what, nothing. They came to my office with their own agreement, all the parties, without my invitation.
But Dr. Ahmadi, you must have agreed to keep the treasure wallet because you had agreed to the fees that Tabarak would receive for the transaction, correct?
No, not correct. I never discussed the fees of transaction because, as I said, only Tabarak's role was to provide a neutral venue, Mr. Salah. And I've said that to the previous council as well. There was no discussion about Tabarak. Anyway, how I agreed with the fees, I've already terminated the relationship between the Tabarak and HUOBI. So from 28 January, there was nothing. The file is closed with Tabarak and HUOBI's file, completely closed. So there is no agreement, such an agreement that they claim. They agreed with Dr. Ahmadi this, they agreed that. It's all sad to hear that. I'm very upset with that because everybody's saying that, maybe as per the agreement, but none of this happened. None of this happened, Mr. Salah.
Dr. Ahmadi, you'd agree that you're the only one who has access to your safe, correct?
Yes, that's correct.
You would agree that Mr. Turner did not have passcode to open your safe, correct?
Yes, exactly. Only me. He and only me. Nobody else. No Mr. Turner, nobody else has.
Only you have, correct?
It's only me.
That's what he's just said, yes.
Sorry, forgive me, my lord, I couldn't hear it for some reason. I've got just a few more questions. Do you know Mr. Morozov still lives and works in Dubai, Dr. Ahmadi?
Yes, I know. He lives and works in Dubai, luxury life, as far as I've been told by Mr. Turner.
And have you met Mr. Morozov since these proceedings have commenced with the claimant?
Yeah, I met him once. I told you by January I met him.
No, I think
after the transaction.
yes. After he's asked you
After the transaction
again after the transaction.
No, I haven't met them. No, sorry, I didn't hear it.
Right. Right.
And Dr. Ahmadi, have you met Mr. Turner after he left employment with you on 20th of June 2020?
I met him a couple of times, yes, Mr. Turner. I met him after he left because Mr. Turner, before he left, first of all, on February, he asked me as a favor to keep his visa. Fine, I agreed because I also wanted to know exactly what happened from Mr. Turner. And then, of course, I've been meeting him all the time. Not all the time, a few times we met because he promised me to solve this problem that he brought to Tabarak, as per his statement. That's why he asked me to keep his visa. I kept it as long as he's going to help the problem that he created with the other parties. Why not?
Have you ever communicated or discussed these proceedings with him?
Proceedings? What do you mean proceedings?
The matter, the case that we are...
Before the trial? Before the trial, you mean, when we started the trial?
Yes, no. Before the trial.
Yeah, before the trial, as I told you, I even met Mr. Turner also outside. Even 1 month before that, we met.
And what did you discuss in 1 month before the trial?
You still discussion. Okay, you want me to tell you what we discussed? He was expressing his sadness to me and unhappiness of what the claimant is going through, what he's doing. What he's doing. The claimant, first of all, allow me to speak, Your Honor, if I'm allowed to say a few words.
Well, yes.
Because it will answer his question, but
yes. I will listen carefully. If anything, you say is inadmissible, I'll let you know. But go ahead.
Thank you, Your Honor. Thank you very much. See, we met many times after that because we know the claimant after the incident. I will just give you this. It will not be more than 3 minutes. The claimant after the incident, he had a criminal case against Mr. Turner and Mr. Morozov. Dubai police investigating, they finance and everything is no problem. He asked for my interference help. I said, okay, I will try to arrange a meeting with Christian come out from jail and all this so and so. And then the claimant withdrew the case while the case was going on with the Dubai police public prosecution against Turner and Morozov. He had a case in the front of Dubai courts against TABARAK, which he lost twice. He completely lost. And then all of a sudden, Mr. Turner asked to meet me urgently. I said, okay, come. We met somewhere outside. He said, you know, the claimant, he waived the criminal case against me, which I understand why. But then he waived the criminal against Mr. Morozov, which is the real suspect on this transaction. We don't know what happened. He was surprised as well. Then later on, the strategy of the claimant was to go after companies instead of individual. Then there was a case against from claimant against TABARAK in the front of the IFC courts. Going on, no problem. We are fighting because we know it's baseless acquisition and everything. All of a sudden, when the claimant realized that Mr. Turner has already opened his own firm in the IFC and started working, they went against him as well. So he owns a company as well. So that's why Mr. Turner was meeting me, expressing his sadness about that. Why HUOBI is doing that? Why that? I said, well, I'm surprised like yourself. Why he's going? As far as I'm here to defend TABARAK. I think all the accusation against TABARAK is baseless, based on nothing. The claimant knows very well who's behind disappearing the coins, whoever they think is what. So the claimant leaving the real suspect enjoying his life, as you said, Mr. Morozov, you said Salah enjoying a luxury life. He leaves him there and he goes after companies, but he might think these companies are registered, they have insurance, they have money, they have this. So this is, as far as I've seen from all the trial, claimant is going after entities instead of individual. I don't know why. Maybe they think entities will have money.
Could you just concentrate on what you discussed with Mr. Turner, if you haven't already covered that?
That's why we were just discussing our, dissatisfactory of the behavior of the claimant. That's all.
I see.
Why he's doing this way.
I see. Thank you.
Did you, during these discussions, month before the trial, say that you don't stand by, that you regretted making allegations in your pleadings and your first witness statement against Mr. Turner?
See, Mr. Salah, I have witness statement before the trial. I also personally met Mr. Turner. I explained to him very well. I said, listen, I got nothing personally against you, but I have to defend and I have to tell the truth. So I expressed my action on this trial. He thinks about it. I'm going against him. I'm going against that. No, I am defending my position. So that is the last conversation we had. I said, I'm defending myself. I have to defend. I have to tell the truth. It's my company. You created this problem for me. I have to defend. You have a case against you as well. You have to defend it yourself. That is the last thing we have.
Thank you so much, my lord. I have no further questions.
Very well. It's time for re-examination, but I wonder when the break is due. Could I hear from the transcribers as to when they were expecting to have a break?
10 minutes.
Sorry?
It's usually after approximately 1.5 to 2 hours, so any time that's convenient, really, please.
Well, yes, we've been going, what?
Your Honor, I need 15 minutes for praying.
Yes. Yes.
If it is possible.
Yes. Well, perhaps it's convenient to take the break now. Now, remind me, is this a 10-minute, a 15-minute, or a 30-minute break? I think
for me, it will take me maximum 12 minutes to 15 minutes.
Okay. Well, then we will rise for 15 minutes now, and then we'll have the re-examination. Thank you very much. That means shortly before 1:30 we shall resume. Thank you.
Thank you.
Thank you.
Yes, my lord, I can.
Good. Okay. Thank you very much. Thank you. That's good. The witnesses there. That's good. Thank you very much, Dr. Ahmadi.
Thank you, Rona. Thank you for giving me time.
No, not at all. That's don't mention. So we're just waiting for Miss Stewart and Miss Ahmed.
I'm here.
That's Miss Stewart, I think. Yes, she is. Yes, Miss Ahmed, are you ready?
I am indeed. Thank you.
Good. Well, do proceed.
Dr. Ahmadi, I want to take you back to a couple of questions that Ms. Stewart asked you on the last day we were convened. I don't think, Your Lordship, the transcript is in the bundle, so perhaps if you just permit me to read.
Yes, certainly.
Dr. Ahmadi, on day 5 at page 105.
Which reference number?
It's not there in any of the bundles.
Okay,
Ms. Stewart asked the following, or made the following statement. Now I'm aware you don't agree, but we would say that Mr. Thurner had already told you that he'd agreed with HUOBI that the account opening fee would be paid from the transaction proceeds. Maybe you were just trying it on at the meeting. Alternatively, you thought at the meeting in your mind, well, they're all here. TABARAK is going to get the account opening fee. TABARAK will get a commission on top, and you thought, well, there are lots of these transactions that are due to happen, so we can make lots more money out of this. And you knew that some of your clients were likely to be interested in investing in crypto assets, and that in turn could lead to further generation of income for TABARAK due to the relationship with HUOBI. And your response to that statement was, yes, I agree with all what you said, counsel. Can I just ask you, did you understand that statement?
I did not, counsel. That was it a question or the long statement? Really, I was a bit confused. That was I don't know if it was a question or a statement. That's why I got really confused. I really, because of this, first of all, as I said, counsel, allow me to answer you this question. Definitely is not true, but I said that because I was confused. Was it a question or a statement? Secondly, it came and long statement. You know, sometimes I get confused with the English language. Although I am educated, very well educated. I have a PhD, everything, but English is not my first language. So perhaps I was really under a lot of pressure, maybe confused, maybe I did not understand the question very well because I didn't know. I was not thinking that was a question, that was a statement. But definitely I don't agree with that. I was really confused. Maybe I was a question after a question giving me on top of my head. I'm human as well. I mean, I get confused sometimes. I go under a lot of pressure. So that's why sometimes, sorry, excuse I mentioned Arabic. Sometimes I could have said something that I don't mean. But definitely that's not, I don't really agree on that.
Dr. Ahmadi, can I take you to then section 8, page 484, please?
484. Yes, I'm here.
You were taken to this email earlier today by Mr. Matu, and it starts
by everybody, I guess, been taking.
Yeah.
Yeah.
Okay. So the chain of emails starts at 8486.
Yeah.
Yes?
Yes.
So an email from Mr. Turner, 26th of January. That's the first chain in the email. Then it goes on at 8485. You see that there? And we see your response.
Yes, 485, the email at the bottom.
And then we see the one from Christian Turner on the 27th of January at 3:41.
Yes, I can see it.
Yes, and then we see your response there.
Yeah.
And it starts Christian, and you gave evidence saying that there was no salutation there was no dear there is because you were angry.
Yeah, definitely. They know the stuff. If I'm angry, I don't do salutation. I don't.
Right. So Dr. Ahmadi, the first sentence there is, we discussed this client in my office last time, and you mentioned that we'll do a test transfer, and I did mention to you that we need to be a client and pay the account opening fee in order to do all these jobs for them. You mentioned there a test transfer. Can I ask you to turn up 26-222, please?
26 page what?
It's a different section of the bundle.
26.
222.
Yeah, 1 second. I'm sorry, I'm just locating that. 26-222, yes, I can see it here, yes.
Yes. So there's no dispute that this is the test transfer that we're referring to. You see the date there, entry date time, 1, 2, 3, 4, 5, 6, 7, 8 entries down from the top.
Yeah, effective date you're talking about, or?
It says entry date time, 22nd of January. You see that?
Yes, effective date is mentioned, yes.
And then at the bottom where it says recipient information, at the bottom there of that section, additional information for recipient, 2020-01-0001, asset sales, OCS-TABARAK. You see that there?
1 second, please, I want to take the page down. Yes, okay, you're talking about additional information for recipient.
Yes, now who is OCS?
OCS is the private company of Mr. Turner.
You were asked questions by Mr. Matu about whether or not Mr. Turner was always acting for the benefit of TABARAK.
Yes, he asked me, yes.
And you've just also given evidence that OCS is Mr. Turner's private company. Was it his private company whilst he was working for TABARAK?
Yes, it was, yes, his private company.
Can you go back to 8484, please?
Can you give me the number again, please?
8-484.
Thank you.
So going back to the first sentence, we discussed this client in my office last time, and you mentioned that we'll do a test transfer. And I did mention to you that they need to be a client and pay the account opening fee in order to do all these jobs for them. Now, we've just seen a document that the test transfer is on the 22nd. When you say in that sentence, we discussed this client in my office last time, can you recall when that was?
I think it is just a few days. I don't really recall exactly which day. If you definitely it is before the test tranche, because I did not agree on the test transfer tranche or anything.
Okay,
So,
can I?
it's before the test tranche, yes.
Can I ask you then to turn to 8472, please? You've also been taken to this email.
Yes, I'm here. I can see it, yes.
Before I take you to this email, just in terms of the email that we've just seen on the 27th, when you say we discussed this client in my office last time and so forth, what was the discussion with Mr. Turner in your office?
The discussion with Mr. Turner was, you know, our procedure exactly. You know, we cannot give any services to any client, being HUOBI or whatsoever, without being onboarded officially, without complying with providing us with full due diligence account documents, without paying the account opening fee. That is exactly my discussion with him.
So when we look at the email at 8472, it's dated the 22nd of January. You are copied into this email. If you go to the second paragraph starting, you need to know that we are only on service for HUOBI and we are not trading anything with you. When you read that sentence, what was your understanding of what Mr. Turner was trying to say?
Yeah, finally, Mr. Turner, he listens to my instruction. He listens to what I said to him. Finally, after I had discussion with him, so he's relaying this message to them. At the end, finally, I said, oh, okay, then he listened to me finally.
And we move down where the sentence starts, board resolution. We don't do for anything related to crypto. We only do digital asset management. What was your understanding of what Mr. Turner was saying when you read that?
Still, I was confused, to be honest with you. Still, I was confused. On the other hand, when I speak to him, I see part of it. He does what I ask him to do. He listens to my instruction. On the other hand, part of it, he mentioned what I told him. The other part, it make me confused as well. Providing crypto, nothing to do with crypto. We only do digital assets. I was still really confused.
Okay, but you've also said he does what I ask him to do. Which part of that do you say was him doing what you've asked him to do?
First of all, when I met him in my office, and secondly, I sent him an email as well, telling him that you know that only we cannot provide service to HUOBI without becoming a client. So yes. I've had a few words with him on that, and from my impression, that he understood what I told him.
Yes, but reading the sentence, we don't do for anything related to crypto. You said he was doing what you asked him to do. What did you mean when you said that?
It means like we are an asset management company. We will do everything, any services that in the complying with our license except cryptocurrency. Because I know he knows, and everybody knows involved in this, that we don't do cryptocurrency businesses because we are not licensed to do it.
And you also said when you read this, that you were confused. Why were you confused?
Yeah, because on the other hand, when I meet him and speak to him face to face, I tell him precisely, please, Mr. Turner, you need to follow our procedure, our rule. You need to onboard the client as per the procedure of TABARAK. We don't provide cryptocurrency. We provide asset management services. We do everything. Yes, I understand, doctor. Thank you very much. Thank you very much. Then on the other hand, after that, he goes and says something else that confuses me as well to other parties. There was a lot of confusion.
And if we go down the last paragraph, not the last sentence, but the penultimate paragraph rather, we are licensed and regulated bank located in DIFC, and this must be far more than enough for you crypto guys to have compliance issues done. We are dealing only with clients which are approved by our own compliance and AML department. Hope you finally understand banking rules and issues. License attached once more. Please note and take this for final capital letters exclamation mark. What was your understanding when you read this part of Mr. Thurner's email? Now
I realized that finally Christian Turner gave them final notice, final warning. Either you comply with our terms, condition, or no business, no relation. I take it as a final notice from TABARAK to HUOBI.
And going back to the email at 8484, the learned judge asked you, why is it that in this email you don't tell Mr. Thurner that this transaction must not go ahead?
Because I discussed with him personally that we shouldn't do this because we don't provide that services. That's why I keep repeating to Mr. Turner, don't provide any services where we are not allowed to. Then of course, time I get assurance from him. Yes, no problem, not to worry. We will do as per our license. We will do as per. So, in a way, you know, sometimes he calms me down. Sometimes he makes me confused. Sometimes also your patience runs out with everything. This is where I come in.
Going back to 8-484. I'm now looking at the second sentence of that email. Now they are sending funds and mentioning digital assets sale, which is not supposed to be mentioned in any transfer in whole UAE. What did you mean when you wrote that sentence?
First of all, yeah, digital assets. I mean, digital, because we cannot accept now anything from HUOBI because they are not client. If any, for instance, now I mentioned that to him. Mention digital assets. Sales is not supposed to mention any trading because, and we will be in trouble in front of our bankers. First of all, the HUOBI is not client. Secondly, it's not. We don't deal with cryptocurrencies. So I tried to explain to him more and more and more about how sensitive is this issue, how dangerous is this issue.
You then, in that last paragraph of the email, say you said also to transfer the sale of 2 BTC to your account as you sold through HUOBI. If this is done through your OCSD company, then why they didn't send to your account? What were you trying to say there?
Yeah, that is still the same. Now, this is I become really angry here. Now, he said they already did two Bitcoin as a tranche. I know if this is for his personal company, nothing to do with Tabarak. So why he used Tabarak account for? Why he didn't use OCS account? He has OCS account. He has in the same bank as well, as far as I know. It's for sure. So since I've been keep telling him, why are you doing this? You don't need to do. And then he does something that disagreeing with my instruction to him. It looks very much here that he's doing it for the benefit of his private company, nothing to do with Tabarak, as per Mr. Salah was mentioning earlier. So there was some deals that he was doing for personal benefits.
You then also gave evidence earlier that after you wrote this email, you had a conversation with Mr. Turner whereby you prohibited him from acting or engaging with HUOBI. Can I ask you to turn to section 9.416, please?
Section 9.416, yes, I'm here.
These are a chain of WhatsApp messages between Christian Turner and HUOBI. It's part of a group WhatsApp chat. And at the top there, it's a message rather written on the 29th of February at 2:57 a.m. Dear all, I have to apologise in the name of Tabarak. Dr. Ahmadi is complaining regarding account opening fees, and I am back from Russia tomorrow. I think that Tabarak is not the partner you are looking for. Transfer will be done as agreed within testing session, and then account will be closed under title Test Failed. I again have to say sorry. Regards, Christian Turner. What do you say about this message? What's that message that was sent by Mr. Turner?
This was finally he informed the other party that Tabarak, we are complaining that we already expressed our dissatisfaction with what's going on between Christian Turner, who was representing Tabarak with HUOBI. He expressed finally, he listens to my instruction that we don't need any more business with HUOBI, terminate everything. So that is what he's trying to explain to them, that since we cannot help you with that, Tabarak is not interested to do anything further more than that.
But he says there, Dr. Ahmadi is complaining regarding our account opening fees. Is there anything you say about that?
Yeah, it is not only account opening fee, Council. It is account opening fee plus complying with the rest of the, providing us with the rest of the due diligence or compliance documents, and being onboarded officially and getting approval from compliance department and everything. It's not only about account opening fee, what everybody thinks at. Account opening fee part of not onboarding the client, but also major part are to provide the required documents that Tabarak asks for anybody or every entity would like to be onboarded. So none of them has happened with regards to HUOBI.
And then finally, where he says transfer will be done as agreed within testing session, and then account will be closed under title Test Failed. And this was despite your instruction to him, wasn't it?
Yes, of course, despite my instruction. That's what I said. I was against it, doing any test transaction or anything.
Thank you, Dr. Ahmadi. I don't have any questions. Thank you. Your Lordship. I don't have any further questions.
Thank you very much. Dr. Armani, that concludes your evidence, and you are released. Of course, you are well entitled to continue to observe the proceedings, but your role as a witness is now completed. Thank you.
Thank you, Your Honor. I appreciate your time, and I appreciate everybody's time. I said what I have swear on my oath, and that was my role. Thank you very much for everybody.
Thank you, Dr.
Thank you. Now, the next witness is Mr. Aziz Malik.
Yes.
Right. Well, we'll just have a brief pause whilst we rearrange ourselves for this new witness. You'll be calling him Mr. Ahmed.
Yes.
And he'll be. Do we know, is he already in position, so to speak?
May I just sort of go off camera and just check?
Yeah,
Positioning.
certainly. Yeah. Yes.
Yes, I think they're trying to organise Mr. Malik, so he should be on screen at any minute now.
Very good. Thank you very much, Mr. Ahmed.
Thank you. Good afternoon, Mr. Malik. Can you hear us?
Yes, I can hear you.
Perfect.
Good afternoon.
Good afternoon, Mr. Malik. This is the judge speaking. Every witness who gives evidence in this court does so having taken an oath, which can be a religious oath or it can be a secular oath. The court draws no distinction between those oaths. Which sort of oath would you like to take?
Take the religious oath.
I'm sorry?
The religious oath.
Take a religious oath. Which holy book would it be?
The Holy Quran.
The Quran. Yes. Would you take it in your right hand?
Mm-hmm.
And listen carefully to me and answer a question which I'm going to put to you at the end of a recitation.
Okay.
Do you swear on the holy book of the Quran that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Lord.
Thank you very much. You're now sworn, and Ms. Ahmed will be inviting you to look at your witness statements. Yes, Ms. Ahmed.
I'm grateful, Your Lordship. Mr. Malik, you prepared one witness statement in these proceedings. May I invite you to turn that witness statement up, please? It's at section 6, page 88.
Yes. I have it in front of me.
You have it in front of you, perfect. Can I just ask you to maybe move the mic closer because it's your voice isn't.
Yes, I think that would be a good idea. Yep.
Yes.
Is that okay?
Yes, hopefully that should work a bit better. So Mr. Malik, you have your witness statement open in front of you. Can I first ask you to confirm your full name and the address as given on the first page of that witness statement, please?
Yes, Aziz Malik of DFC Burj-Zaman West Court, Level 2, Office 208 Dubai, UAE.
Thank you. And can I ask you to turn to the last page of the witness statement? It's at 6 103.
Yes.
Mr. Malik, there is a signature there dated the 10th, or rather the 12th of October 2021. Do you confirm that that's your signature?
Yes, it's my electronic signature.
And therefore, do you confirm that the contents of this statement are true to the best of your knowledge and belief?
Yes.
I'm grateful. Mr. Malik, you'll be asked some questions by counsel for the claimant and the second defendant. If you'd like to remain there, please.
Thanks.
Mr. Malik, hello. Now, if I could take you to your witness statement, paragraph 6, please, at 6-89.
Yeah. Number 6.
Yeah. Now, in that paragraph, you say, in your present role, you oversee and ensure that TABARAK is compliant with its external regulatory and legal requirements, as well as TABARAK's own internal policies and procedures to help TABARAK identify and manage regulatory risk.
Mm-hmm.
In the event of such a risk being identified, you assist and provide advice to the head of HR concerning appropriate disciplinary measure that may help and avoid a future recurrence.
Yes.
Now, was that your role at the time of events that are subject to these proceedings?
The role when it comes to advising in relation to HR, that's very brief. That's extremely brief. There is a HR director who...
Sorry, you're saying is. I'm interested in what your role was at the relevant time.
My main role is a compliance officer, MLRO, and risk management.
Right. Okay. Now, and if we go to 8477. Oh, right. 1 minute. Sorry, forget that. TABARAK's website at the time of relevant to these proceedings shows that you were at that time a member of the management team, as you are now, yes?
Yeah, but what do you mean by management team?
Well, on the website, it has the title management team, and it shows you on the management team.
Well, that simply just means that a more senior role compared to junior staff, that's all.
And it also includes in your responsibilities corporate governance.
Mm-hmm.
So that means that you're also responsible for establishing a system of rules, practices and processes by which TABARAK was directed and controlled. Is that correct?
Mm-hmm.
So really, as a compliance, risk management and corporate governance officer, your task was basically to ensure that TABARAK had internal controls that adequately measure and manage the risks that it faced.
That's correct. It doesn't mean that the people concerned will abide by those laws.
Sorry, could you just repeat what you said?
The controls are in place. It doesn't mean that the laws and rules are abided by.
Now, you say that you've worked in the field of compliance and risk management for some 13 years. So by late 2019, you'd been working in the field for, say, 11 years, yeah? So you would say that by that stage, you had a lot of experience in this type of role.
I've been a DFSA authorized individual since 2008 or 2009, if I remember.
And that you have a lot of it, and
Yeah.
would you say that, and it was in this role that you had that experience, yes, for about 11 years? Now, I'm going to invite you to agree that a number of activities are included in the role that you had, namely the role of a director or someone called a director, who's responsible for compliance, risk management and corporate governance of a regulated investment bank.
Yes, but I'm not a member of the board.
Okay.
I'm not a member of the board.
No, I understand that. First of all, it was your role to ensure that appropriate training was given to new employees on TABARAK's internal policies and procedures.
That's correct.
And you would agree that your role was to ensure that internal policies and procedures should be set out clearly in internal documents so that there can be no room for doubt as to what they are.
That's correct. I just mentioned that all these policies and procedures are looked at by the DFSA as well as audits every year, internal audit and external audit.
And that you would agree as part of your role that if it's thought that an employee is in breach of any relevant laws and regulations and internal policies or procedures, that one, those matters should be reported to you.
That's correct.
And two, these matters should be properly investigated. Three, that this investigation should include consideration of relevant documents.
Which documents you mean?
Relevant documents.
Relevant
To the possible breach that you're investigating.
Yes, correct. Yeah.
Yeah.
And that in relation to a serious potential breach, for example, one, not least one that involves significant sums of money, typically an external law firm would carry out the investigation.
I believe the HR looked. Are you talking about after the event of February?
I'm just talking in general principles.
But generally, I
if there's been a serious breach, including a breach that involves the loss of significant amounts of money.
Yeah, definitely.
And that for that type of breach, then a search of all potentially relevant documents should be made.
Yeah, I believe so.
And once those documents have been located, they should be stored for safekeeping.
Yeah, that's correct.
Now, would you also agree that in the event of a potentially serious breach, that a responsible compliance officer of a regulated bank, so someone in your position, should suspend an employee pending completion of a proper investigation?
I don't have the authority to suspend anyone.
But do you agree that the standard practice would be that while an investigation into a serious breach is being carried out, you do not allow that person who is subject to the investigation to carry on working and representing the firm to clients?
Are you talking about the events after the 3rd?
I'm talking in general terms.
I can't really give you that answer. It's general. It depends on the situation. I can't. If you want, I can explain the situation to you directly.
So let me ask. So, an individual, an employee, is under investigation for a serious breach of internal procedures, and let's say that breach may have led or caused a very significant loss.
But when
are you suggesting that while the investigation is being carried out, that employee should be allowed to continue to work and while that employee is under this cloud of suspicion?
I wasn't aware of anything which happened until after February the 3rd.
No, I asked you a general question.
Generally, I don't know. I don't know generally. I can't answer that question generally. I don't know. It depends on the circumstances. It depends on the situation.
Well, look, just think about it. Council's put to you a pretty specific situation. There's been an apparent serious breach of an internal rule or regulation or policy. And it is possible that the breach will have caused significant loss to the firm. In that sort of situation, would you suspend the employee, or would you permit the employee to carry on working and representing the firm?
I think that in such a situation, it depends on what information I had to hand. We would do, and we would look at everything. We'd interview the person itself, and if that person is denying what happened, is denying everything at the time of the example you're talking generally, I would need to find out what had happened. I'm not an investigator. I'm just simply there to try to ascertain what had happened after this February the 3rd itself. But generally, I do not know until I have the circumstances. But if it was a serious matter and evidence was pointed all at that person, yeah, probably maybe yes.
Now, would you also agree that an individual in your position should be informed if an employee is marketing products and services that that employee is not authorized by the firm to market? That's part of your role. And also that once you have been informed of that, your role is to ensure that it's made clear to the employee to cease that activity.
Correct, if I was aware of it, definitely.
So, your boss was asked a question today. Dr. Ahmadi was asked a question by Mr. Matu. The question was, you must, and it was in relation to the document at 8421.
Yes, I have it in front of me.
And in relation to that document, which is an email about first transaction of 1,000 digital asset Bitcoin, first order for 1,000 pieces of Bitcoin, and then the body of the email talks about a new wallet address, and so on. Now, the question asked was, you must have spoken to your director of compliance saying, you know, Mr. Aziz, this has come to my knowledge. Did you? And then Dr. Ahmadi's response was, compliance officer will not be involved himself in this type of thing. This is not a compliance, because compliance will only jump in if it's one of our clients doing this. Compliance is a way out of this question, out of this procedure. But you've just said that you consider it to be part of your role, that if an employee is marketing products and services that it's not authorized to, that you should be informed of that. So I'm putting to you that actually what Dr. Ahmadi was saying here, his response was incorrect. His understanding of your role is rather different to yours.
I don't understand the question.
In essence, Dr. Ahmadi was saying that if one of your employees is marketing products and services that they're not authorized to, so services, for example, to do with cryptocurrency, in this crypto assets in this case, that you essentially shouldn't be informed of that. It's not part of your role.
Well, he was putting it in the context that the client relationship had not been onboarded, that this client had not been onboarded, and therefore, until a client is involved in a transaction such as this, then the matter wouldn't be relevant to the person involved with compliance with and procedures.
With respect, Your Lordship, that was Dr. Ahmadi's answer to this. The question that I asked, and that I am asking, or that I asked, and to which I was given a straightforward answer by Mr. Malik, was that if an employee is marketing products and services, it doesn't matter to whom, whether they're a client or not. If those products and services that are being marketed under the TABARAK banner are products and services that the employee is prohibited by TABARAK from offering, then you, Mr. Malik, would be should be informed about that, because you don't want your employees marketing products and services that they're not allowed to.
I don't want any employee to do anything which is out of our scope of license. Simple. Doesn't matter what they say, what they do, they are not allowed to do it. If it's not under our scope of license, they're not allowed to do it. Simple.
Well,
So,
can I ask you this? I'm so sorry, Mr. Stewart. Just bear with me for a moment. If you had been, were you copied in on this?
I haven't been in any email whatsoever. Yeah, no,
right. So, but if this email had been drawn to your attention, would you have intervened in your role as compliance officer?
100%.
100%.
Yes.
Thank you. Now, do go on. Forgive me for interrupting you, Mr. Stewart.
thank you, I'm grateful. And would you say also that in the event that you've discovered that that an employee has been breaching internal procedures and protocols and so forth, that appropriate disciplinary measures should be in place?
Yes, if it was found that they were in breach of their employment, yes. But then again, it's not for me to say, it's for HR and for the SEO and the board. I can't make a decision on this.
But it would be part of your role to work with HR to establish what should happen.
Very basic and very basic. I'm not involved in everything, no, I'm not. But I would be, they would ask my opinion on things, yes, correct.
Now, would you agree also that if it has been established that there's been a breach of a legal or regulatory obligation by TABARAK or any of its employees, that TABARAK should self-report to the relevant authority?
Yes, correct.
And would you also agree that a compliance officer and risk management officer in your position should maintain an objective view of company policies and measures, and so shouldn't be influenced by other senior management so as to dilute those rules and procedures?
I would never do that. My name's on the line. My name's registered with the DFSA as an authorised individual, so I would not put my name on the line for anything. It could have dire consequences for myself personally, so I would not do that.
No. And would you agree that in event legal proceedings are being threatened or they're on foot, that all relevant documents should be searched for and preserved?
Yes, I believe that they were from the IT department, which is outsourced.
Now, at the time of relevant events, those were pre-COVID times, which seems a long time ago. But anyway, you were then working full-time for TABARAK, weren't you?
Yes, correct.
And you worked from TABARAK's offices?
Yes, correct.
You didn't work from home or?
Occasionally I wouldn't be in the office. I'd be in the DIFC. Occasionally I'd be home. I wouldn't be in the office every day, 9 till 5, no.
But what, 90% of the time, could we say?
No, not 90% of the time. It depends on the day. It depends if I have some workshops to attend. It depends if there's any conference in Abu Dhabi or in the DIFC. It depends. Yeah, it could be anything. Meeting up with relevant other compliance officers. Anything.
Yeah, standard stuff.
Yeah.
Now, if we go to 6101, just get this point out of the way. Now, as I understand what you're saying at paragraph 43.6 is that you're denying that Mr. Thurner's title was Director of Investment.
Right. I was always led to believe he's an investment manager.
Well, need I take you? Well, let me put it this way. I understand that, or I could see from the list of attendees in court that you've been sitting in on the proceedings.
Not all the proceedings, no.
Okay. Well, let me ask you again. Let me ask you differently then. Do I need to take you to the numerous TABARAK emails that Mr. Thurner sent which bear the title Director of Investment?
I've never been copied in on these emails.
So you're not aware of emails where he always signed off as Director of Investment?
Tell you the truth, I'm not 100% sure. No, I'm not 100% sure.
Right. So you weren't. So at the time, you weren't even aware of how a member of staff was holding himself out to the world.
From my understanding, he's an investment manager. He's not on the board. He's not a board member.
So you weren't aware? No,
he's not. I'm saying he's not a board member.
Now, you say at paragraph 10 of your witness statement that all new members of staff are given training on TABARAK's internal practice and procedure.
Correct.
And you expect the court to accept this at face value without any hard evidence in support of this, right?
Every employee, new person who attends the office is given a workshop with each relevant department in terms of the rules and regulations. That means in terms of RM, his duties or her duties, compliance, what they're supposed to do and what they're not supposed to do, finance, etc. So yes, I'm saying that they are all given relevant information and training.
You haven't provided any hard evidence, have you? You haven't provided any documents in support of any training that Mr. Thurner and Ms. Zaviolova were given. Not a single training manual, not a joining pack, nothing whatsoever.
We don't really have a joining pack, no. But we do provide them with the information that's required. Well, they are definitely aware of what their roles and responsibilities are.
Well, are they simply given these documents, or is there some in-person discussion and conversation that goes together with the production of the written material?
They're provided with relevant information as to the rules and regulations. They go through everything with the relevant department as to what they're allowed to and what they're not allowed to do, to the rules, and in relation to our policies and procedures as well, in terms of HR. Every single person is provided this training, and that is on an oral basis also.
So are there or are there not written documents setting out internal policies and procedures and the and what each employee is allowed and not allowed to do, and what the relevant laws are and regulations?
We have all the policies and procedures in place.
Sorry, I asked you a question. Are there any written documents?
Some policies and procedures which are in place.
There are written policies and procedures, and none of these have been provided in this proceeding.
They're in our compliance manual, they're in our AML manual, they're in the finance manual.
None of which have been provided.
Compliance manual, you sure? All the compliance manuals and AML manuals are a must in any regulated entity, and we provide these to the audit as well as DFSA, internal and external, and as well as the the employees who come to the office who are starting new. They're all aware of everything.
Now, the closest you get, I mean, at paragraph 10 of your witness statement, you set out an apparently very rigid procedure that would lead to the onboarding of a client, yes?
That's correct. This is taken from the DFSA.
Now, the only document that you provide in support of this allegedly rigid procedure and the training that presumably that you're saying Mr. Thurner and Ms. Saviolova were given is an internal email to Mr. Turner dated the 17th of July. If I could take you to that, that's at 8:59.
Yes.
So you rely on this in support, as I said, of TABARAK's alleged protocol. Now, first of all, this was provided in July 2019. So it wasn't even provided when Mr. Turner joined, which was months earlier, was it?
I'm sure he was provided one before that.
In fact, we can see that it was provided pursuant to a request by Mr. Thurner, because it says, please find below as requested.
I've sent these to every RM in the firm once they joined. As soon as they started to join, on occasions the RMs say, can you resend it to me?
Now, so this is an email titled Account Opening Procedure, and it says at the top, for corporate, investor submits, so investor submits all DD requirements and opens an account with TICL bracket 25,000 US, processing fee non-refundable. Now, 2 points on this. In your witness statement at paragraph 8,
Okay.
that's at 690 for the record, you say that the amount varies from client to client, but the standard template provided for an account opening fee of $30,000.
Okay.
So you would accept, therefore, would you not, that this cannot be the standard protocol? What's set out in the email can't be the standard protocol because it doesn't refer to a processing fee of $30,000.
As I mentioned in my witness statement, the fees vary, it depends. But generally it was previously in 2019, 25. Can I also add, I'm not the person who decides on how much is charged.
Now, and nor does it say anywhere in this email the processing fee is determined by Dr. Ahmadi. It doesn't say that either, does it?
No, it doesn't. It's just a standard email to require documents, nothing else.
But you're relying on this in support of the alleged protocol for onboarding a client, aren't you?
I'm not relying on the 25,000 myself personally. I'm actually relying on the documentation that I require.
And nowhere in this email does it say what the precise order of events need to be. Namely, it doesn't say, for example, that 25,000 or 30,000, whatever it is, can't be paid out of transaction proceeds. Doesn't say that, does it?
You can't do a transaction without the client being onboarded.
There's nothing here to say that you can't do due diligence first. The client's onboarded and it's agreed that the transaction, that the fee will be paid out of transaction proceeds. It doesn't say that here, does it?
If you want to refer to the account opening agreement standard, when it does state that they cannot do any work unless they're onboarded, no services are provided until all the obligations are met by the potential client.
So basically, this email doesn't set out a standard protocol and it doesn't set out the rigid procedure that you detail at paragraph 10 of your witness statement, does it?
Do you mean in that simple email?
Yeah.
Yeah, that simple email is just for him, a reminder to the RM at the time. It's a simple reminder, nothing else.
Now, going back to your witness statement at paragraph 29.
Yes.
You say that this is a list of documents that TABARAK would ordinarily require. So, can you see that?
Okay.
So you accept that it's for a particular client. It's not always necessary for a client to provide all of the documents in this list.
I didn't say that.
But you said ordinarily require.
Can you point me to that?
Okay, so 696.
Okay.
Mr. Thurner knew that the list of required fell short of the list of documents TABARAK would ordinarily require as set out in my email of the 17th of July.
Yeah, they did fall short.
But what I'm saying is that with a specific client, you may not actually require each and every one of those documents.
Sorry, that's incorrect. I did not say that. I never said that.
Right. Now, you say in your witness statement that prior to the Dubai police attending TABARAK's offices on the 3rd of February, you were unaware of Mr. Turner's dealings with HUOBI and Mr. Morozov.
That's correct.
You sure about that?
100% sure.
Right. Now, I understand that you heard at least some of the evidence of Dr. Ahmadi last week and today.
Okay.
Did you hear all of it?
I'm not 100% sure I heard all of it, but I heard some of it.
Are you aware, at least from what you heard, that members of your staff, members of TABARAK, so TABARAK employees, namely Dr. Ahmadi, Mr. Qadir Khan and Ms. Saviolova, were copied into various emails involving TABARAK and HUOBI, using TABARAK and HUOBI email addresses?
Did I hear his evidence, you mean?
Yes. Were you aware that Dr. Ahmadi was being taken to a number of emails into which he and Mr. Qadir Khan and Ms. Saviolova were variously copied into?
Yes, I heard this evidence.
Now, just to summarise, I referred to at least 13 emails in my cross-examination that were in fact copied in to Dr. Ahmadi and Mr. Qadir Khan, or either of them. And in order to spare the court, I won't go through each and every one of those. However, you would agree that there was a significant amount of email traffic between from about the 20th of December to through January, involving various TABARAK employees.
Yeah, that's correct.
And have you seen those emails?
I've seen them now, yes.
You've seen all of those emails, yes?
Afterwards, yes.
Okay. Now, now you know, well, we know that there were various meetings that HUOBI had at the TABARAK offices. Yes, I don't think it's in dispute that there were meeting on the 16th of December, yes, for example.
You asking whether I know there was a meeting on the 16th of December?
Yeah.
Well, no, I didn't know there was a meeting on the 16th of December.
But do you accept now that there was a meeting at the TABARAK?
Yes, yes.
Do you accept now that on the 29th of January, Mr. Saxena attended the TABARAK offices?
Yes, I've only known now. I didn't know at all.
And do you accept that Mr. Saxena and Mr. Nahak also attended the HUOBI offices on the 30th of January?
I don't understand. So HUOBI's offices, I don't know.
Sorry, TABARAK's offices.
I don't know, but if it's recall, then if they gave evidence on this, yes, but I don't know.
Okay. And then I don't think it's in dispute that HUOBI also attended the TABARAK offices on the 3rd of February.
Okay, as per what they've stated, yes.
Sorry, but you're not disputing.
Well, I don't know. Are you asking if I knew the time, or you asking that I knew afterwards?
I understand. And Mr. Thurner also had telephone conversations with Mr. Al-Ali.
I don't know.
Not aware, right.
I don't understand.
And Mr. Turner sent an account opening form to HUOBI, which contained the TABARAK seal.
Okay, you're telling me this, and from the evidence, yes, but I don't know about this.
Right. And also an invoice was sent on the 29th of January that similarly contained the TABARAK stamp.
Okay.
You've seen that invoice?
I've seen it after the events.
Yeah, I know you're saying it's all after the event, yeah.
Everything I am saying in relation to this is after the event. Because, yeah.
Now, at the time, TABARAK only had, what, 8 or 9 staff?
Maybe, yes.
And as Dr. Ahmadi himself admitted, it's small office premises.
Mm-hmm.
And Dr. Ahmadi himself agreed in cross-examination that TABARAK is a bank where everyone knows everyone else and you know what everybody is doing. Would you agree with that?
TABARAK's not a bank.
Well, he agreed to that statement, but so let me put it another way. Do you agree? Dr. Ahmadi himself agreed in cross-examination that TABARAK is a company where everybody knows everyone else and you know what everybody is doing. Agree with that?
You don't know specifics, no, but everyone does know everyone, that's correct.
Thank you. And given the volume of and the nature of the email traffic, the in-person meetings at TABARAK, the use of the TABARAK seal and the stamp, I suggest to you that it is wholly improbable that you were unaware until the police came on the 3rd of February of TABARAK's dealings with HUOBI.
I was actually unaware until the next morning after the police had went, not on the day.
So basically what you're inviting the court to find is that you turned a blind eye to what was going on under your very nose.
I understand the police arrived in the evening.
I didn't get that last answer. Could you repeat it, please?
Yes, the police, I understand, arrived after 6 o'clock.
So you had
Were you aware that the police had been summoned?
Not really, no, not at all. I found out after everything, whatever's happened, I found out after the 3rd of February.
I see.
Rather unusual, wouldn't you say, that given your role as compliance officer, you weren't called up immediately when millions of dollars worth of Bitcoin goes missing?
Well, they're not our Bitcoins, so I don't understand. Why would I be called? The police have come to the office, I believe, in the evening, and I understand that I think it was Christian Turner, Anastasia, buyer and seller, I think, were arrested. And when I came to the office the following morning, that's when I found out and started to find out what's going on.
So in your role as compliance director, risk management, in charge of risk management, corporate governance and so on, do you not find it extraordinary that when the Dubai police attended TABARAK's premises on the 3rd of February and that 2 of your employees were taken into custody, you weren't one of the very first people that Dr. Ahmadi called?
No, I believe Dr. Ahmadi was in the office in the evening when the police had arrived, because I believe that he was called, but no, I was not called.
Well, implicit in the question was, well, aren't you rather surprised that you weren't called in those circumstances? So that you knew before the police arrived that a serious event had occurred involving Bitcoin and a significant loss to the company.
I was surprised when I wasn't even told about any of this. I was surprised that the police had arrived. I may be a little surprised why no one informed me, but it's not my role in relation to this. It's not my role at all.
Well, with respect, Mr. Malik, it's difficult, therefore, to understand what you think your role is, if not to be there immediately when the police have visited TABARAK's offices and 2 of your employees have been taken into custody.
I was not aware, I'm sorry, I was not aware of it. Nobody had told me. It's not my fault, nobody had told me.
Now, Dr. Ahmadi has gone to great lengths to emphasise that TABARAK employees were prohibited from involving TABARAK in any crypto asset related activity. Yes?
Yeah. We're not allowed to do crypto, full stop.
And yet you're expecting the court to believe that despite this, neither Dr. Ahmadi, Mr. Kadir Khan or Ms. Saviolova warned you that Mr. Turner was involving TABARAK in crypto-related business.
Yes, that's correct. Nobody told me.
But you would have expected to be told, wouldn't you?
Yes, I believe so.
So don't you find it a little strange that you weren't told?
Yes, I was very surprised.
So either there was a complete breakdown of an internal processes, or you knew exactly what was going on, but you weren't at all bothered by the fact that TABARAK was involved in crypto-related business, because you knew that TABARAK, and particularly Dr. Ahmadi, was happy to make money from HUOBI's crypto-related business. So which one's it to be?
It's neither of them, sorry. I was not aware and I was not involved.
So you don't believe, therefore, that there was a complete breakdown in internal processes?
I believe there was a breakdown in communication.
Well, and on the basis that it would surely be expected, and Dr. Ahmadi and Mr. Qadir Khan would have known that you should be informed of this jolly into crypto-related business, and the fact that you were not informed, would you therefore agree that that was a breakdown of internal processes?
The issue here is this: I'm not aware. I wasn't aware of anything which happened.
No, I'm asking you a question. Does it mean, therefore, that there was a breakdown or there was not a breakdown of internal processes?
I believe that I should have been told.
Thank you. So you do agree?
No, I said I should have been told.
So do you agree or do you not agree that there was a breakdown in internal processes?
I don't know whether they follow them.
Come on, Mr. Malik. Now just listen to me carefully. You've explained that within the company, you would have expected to be informed if a member of staff was aware of dealings, let's say, in cryptocurrency. And you would have expected that because that's implicit in the obligations on the staff, which arise from the protocols and the procedures which they are given.
That's correct.
Yes. So I take it that on that analysis, there has been a breach within the company of an implied obligation to report to you transactions which appear to be being negotiated, which are transactions which are not within the license.
That's correct.
Yes.
But in fact, the reason nothing was reported to you, if that was the case, is because Dr. Ahmadi and TABARAK was very happy to be engaged in this crypto-related business.
You can't answer that question, Mr. Stewart.
I can't answer
Not for this witness.
Can I take you to paragraph 11 of your witness statement? That's at 692.
Yes.
Now, you talk about relationship managers being aware that until you confirm a client has been onboarded, the due diligence process remains pending. An employee should not provide financial advice or services or undertake or conduct any financial activity for or on behalf of the prospective client.
That's correct.
But you would accept, would you not, that Dr. Ahmadi was aware well before the 3rd of February that advice had been provided to HUOBI by Mr. Turner, and that advice was in relation to a Bitcoin transaction?
I don't know whether he was aware or not. He's given his evidence. I can't give evidence as to what he thought or what he knew. I don't know.
Let's assume that Dr. Ahmadi was aware that advice had been provided to HUOBI in relation to a Bitcoin transaction, and this is something that the learned judge will be deciding. Let's assume that were the case, then you should have known about that, shouldn't you?
Nobody told me.
No, the question is, you ought to have been told about that.
If any service was provided to a client, which is
Price was being given by TABARAK in relation to a Bitcoin transaction.
I should have been told yes.
Now, can I intervene again? And do you accept you should have been told where there are negotiations as to a participation by TABARAK in a Bitcoin transaction, which are going on before the client relationship agreement has been signed?
My lord, when it comes to me being informed, first of all, if it was for any other potential client, I would not be informed. But because it's strictly crypto, I would want to be informed.
Well, want to be informed, you would have expected that if the rules, protocols, and so on were being properly and openly administered, that you would be informed. Do you agree?
Yes, correct.
Yeah.
And furthermore, if financial activity has been conducted by TABARAK for HUOBI before what you call onboarding has occurred, then you would similarly expect to be informed, wouldn't you?
Yes.
So in this case, we know, we've heard from the evidence that there were 2 test transactions, both involving TABARAK's bank account. And you accept that?
Okay, from the evidence, yes.
And you don't deny, I presume, that Dr. Ahmadi knew that these test transactions involved Bitcoin.
I don't know what he thought. I don't know what he's thinking. I don't know how he read the email. I don't know. I can't answer.
Put the question on a hypothetical basis, Mr.
Yeah. So let's assume that these test transactions involved Bitcoin, or even if one of them involved Bitcoin. And let's assume that Dr. Ahmadi was aware of this, or Mr. Qadir Khan was aware of this. You would expect to have been told.
That's correct.
At the time.
Yes.
As soon as this was discovered.
Definitely.
Now, Dr. Ahmadi has said that he was furious about the test run, and then he elaborated in cross-examination, saying by furious, he was very angry, very upset. Yet you're saying you knew nothing, of course, about TABARAK's dealings with HUOBI until after the police arrived on the 3rd of February, yes?
Yes, correct.
So, with respect, if Dr. Ahmadi was indeed furious, is it not improbable that he wouldn't have informed you about these test transactions, you being the compliance officer?
Yeah, he didn't tell me.
No. If he was furious, surely he would have told you, would he not?
Well, he can't answer that.
Don't know.
He can't answer that. He said that he would have expected to be informed, and that would be part of the proper implementation of the internal procedures and protocols. But he can't answer that particular question. That's for Dr. Ahmadi, and you've explored that with him.
Now, in your witness statement, you express concern and general surprise about allegedly discovering after the 3rd of February that due diligence documents were sent by TABARAK to HUOBI.
Yeah.
Now, if we go to 8-371,
Yes, I have in front of me.
we can see here that Dr. Ahmadi and Mr. Kadir Khan, your finance director at the time, they were both copied in on such due diligence documents, weren't they?
Yes, it says that, yes.
And they didn't, nobody internally at TABARAK raised any issue with you about the provision of these KYC documents at the time, did they?
Yeah, that's correct.
So are we to believe, therefore, that this was, is the court invited, therefore, to find that there was yet another internal breakdown?
You can't ask if the court is invited, because this witness is not the client.
So, yeah.
So rephrase it.
Would it not be correct to say that there was yet another breakdown of internal processes?
Yes, they should have told
him. Now, let's move on to the issue of correspondent banking. Now, would it be fair to say that correspondent banking, it's the provision of a current account or another type of account, and sometimes related services to another financial institution, or it could include affiliates as well, and it's used for the execution of third-party payments, and it can be used for cash clearing as well, liquidity management, short-term borrowing, and so on. Would you agree that, in broad terms, that's what correspondent banking is?
Okay.
Well, do you agree or not?
Well, he said okay, in case you didn't hear him. I think that means he's accepting what you said.
Okay. So a correspondent bank is effectively acting as its correspondence agent, conduit, executing and processing payments or other transactions for the correspondent's customers, yes?
Yes.
So, Noor Bank is TABARAK's bank. I don't know whether it's the only bank that TABARAK banks with, but that's certainly the bank that we've seen in the documentation, yes? And we've seen also in the documentation that Noor Bank has, for example, a correspondent bank in Europe.
Okay.
Do you agree that Noor Bank has a correspondent bank in Europe?
Well, I don't know. I don't know that. I think most banks have correspondent banks in various different countries, Europe and the US, etc.
So you're not actually aware of, you're not familiar with what banking details are sent to clients, or let's leave it neutral, potential clients.
That's the job of the finance officer.
Right. Now, in and then we saw in one of the, I think it's called the third deal structure email, that TABARAK had at least one correspondent bank.
I don't understand what you mean.
Better put some particulars to the witness about that.
Yeah. Okay, we go to 8421.
Yes.
Evgeny has placed, have you got that?
Yes.
Okay, thank you. Evgeny has placed verified funds with us at correspondent bank in Europe. Now that could mean one of two things, either a correspondent bank of TABARAK or potentially a correspondent bank of TABARAK's bank. Do you know which one it was?
We don't have a bank in Europe.
A correspondent bank, so a bank that that acts as a correspondent in the way that I've described.
Correspondent bank would be for a bank such as Noor or HSBC or Citibank or these types of banks. TABARAK doesn't have this.
Okay, understood. Now, going to paragraph 38 to 40 of your witness statement.
Yes.
Now, as I understand it, so this is all about the Wolfsburg questionnaire response.
Mm-hmm.
Now, you're in effect saying that the filling in and transmission and sending of this report to HUOBI was yet another unauthorized act by Mr. Thurner.
I'm saying that I didn't complete this Wolfsburg Group correspondent banking due diligence report. No, I didn't sign it either. I can't say who signed it, but I'm saying that I didn't sign it. I don't want to blame somebody else where I don't have the information for that.
So you're not actually saying that Mr. Thurner was unauthorized when he filled this in and when he sent it attached to that email?
Usually, whenever compliance from a different company requires documentation, they would liaise directly with the compliance officer for the company, in other words, myself. I've never liaised with any compliance officer at HUOBI. There's also a document for HUOBI which has been signed by Christian Turner, and it states at the bottom to be signed by compliance officer. Why wouldn't I sign that either? I should be signing that.
Well, I'm sure that my learned friends, Mr. Mattu or Mr. Kotnik, will be asking questions on this. But as we've already heard, Mr. Thurner did copy Dr. Ahmadi into this report. And it's really improbable that he would have done if Mr. Thurner had actually concocted this report. But anyway, notwithstanding that, you say at paragraph 40 of your witness statement that the signature on the Wolfsburg report isn't yours.
Correct. But
so there you'll make
the Wolfsburg report is very, very easily available on the internet, and you can just download it, I believe, and it holds no weight anyway, so I don't know why this was sent in the first place.
But you're making a very serious allegation there that this is forgery.
I'm simply saying that I did not sign this document.
So it purports to be your signature. So let's not beat around the bush. You're saying it's a forgery.
It's not my signature. My signature is not a squiggle.
Right, you're not really answering the question, but anyway.
The lawyers know what the legal significance may be of a signature that purports to be the signature of A when it is not the signature of A.
But you haven't provided any expert evidence at all from a handwriting expert in support of this not being your signature.
Sorry, but why would we? Because it's not an issue in the case. There is nothing that falls on this issue. It's not the pleaded case.
Well, Miss Ahmed, it's your client who's brought it up in their witness statement.
Wait a moment.
It's not a pleaded issue, and therefore, why would we even try and get a handwriting expert?
Well, perhaps we can leave that for closing submissions, Miss Ahmed. Now,
Yes, go on, Mr. Stewart.
Now, in your version of events, Mr. Malik, you were also unaware that TABARAK wanted to be a client of HUOBI.
Correct.
Well, I'd suggest that that also is a nonsense. If we go to 48449,
I beg your pardon, I don't really understand. What does nonsense mean?
No,
in this
just
context?
Miss Ahmed, just that interruption. It's inappropriate.
My apologies, I just didn't understand the question, Your Lordship.
Go on, Miss Stewart.
so there you'll see an email dated the 21st of January 2020, Mr. Thurner to HUOBI, copying in Dr. Ahmed and Mr. Qadir Khan. And it says, penultimate paragraph, make our account with you active and usable.
Okay.
So I suggest to you that you knew at the time that an application had been made for a HUOBI account.
I didn't know. I was not copied in the emails.
So in the small office, nobody, it didn't come to your attention at all that TABARAK wanted to have an account with HUOBI.
That's correct.
Mm. So you would agree that, assuming that TABARAK wanted to have an account with HUOBI, and this will be a matter for the judge to decide, that's something you ought to have been told about.
Well, as I mentioned before, whenever there's correspondence between compliance officers from various companies, they always email the compliance officer for the other company requesting documents. It's never through an RM directly to a compliance officer. So the compliance officer of HUOBI would be sending me the emails. I'd be sending back and forth emails to the compliance officer at HUOBI. If we wanted to open an account at HUOBI, I would have signed that document for HUOBI as well.
So what you're saying is here there was a breakdown in internal processes.
Yes, I'm saying that I should have been told about this.
Thank you.
Can you help me with this? There's a reference to RM, to an RM. I'm not familiar with that, or if I ought to be, I'm sorry.
That's relationship manager.
It's
oh, yes, the relations manager. Yes, I've got one of those. Yes, and they're known as RMs. Okay.
Sorry.
Thank you very much. Go on, Mr. Stewart.
Now, you agreed that if it's thought that an employee may be in breach of any relevant laws and regulations and internal policies or procedures, that it was your role to ensure that the matters were properly investigated.
It's not my role, it's HR's role. I was just giving advice whenever they needed it. So it's HR's role really to go through everything with the employee, see what happened exactly, speak to the SEO. I have no authority to have somebody suspended in any way.
No, I'm not asking whether you've got authority to have someone suspended. Would you not agree that in your role as head of risk management and compliance, you should be doing all that you can to make sure that in that eventuality, namely it's thought that there's been a breach of any relevant laws, regulations, internal policies and so on, that the matter should be properly investigated?
Yes, I discussed this with Dr. Mahdi as well as HR.
Not asking whether you discussed it, you agree in principle?
Yeah, definitely.
Right. And I recall that you agreed that in relation to a potentially serious breach, you agree that a search of all potentially relevant documents should be made. Those documents should be considered. They should be preserved.
Yes, correct.
Now, you would agree that the events on the 3rd of February related to a very serious theft.
Correct.
And that 2 Tabarak employees, Mr. Thurner and Ms. Zavialova, were involved in this. And again, as I said to Dr. Ahmadi, we're not saying that they were necessarily the ones who themselves stole the Bitcoin, but they were involved in events directly related to the theft.
Following on from the information I was provided, I am aware of what happened during that meeting, as told by Christian Turner.
That isn't my question. And you were aware that this very serious theft not only involved 2 Tabarak employees, but it also was directly related to activities carried out in Tabarak's offices.
Yeah, the incident happened in Tabarak's offices, yes.
And in fact, the seriousness of Tabarak's involvement is very much emphasised, is it not, by the fact that Mr. Thurner and Ms. Zavialova were taken into police custody.
Yes, but I understand that the case was dropped against them.
Yes, well, that came later.
Yes.
And the police also thought it was so serious that they took laptops and mobiles of those 2 employees, didn't they?
Correct.
And on Tabarak's version of events, this involved Mr. Thurner and Ms. Zavialova engaging in crypto-related activities which they were prohibited from doing by Tabarak.
Yeah, they are prohibited from doing it, yes, correct.
Yeah. And they were involved in those activities.
I don't know if they were involved in this transaction. I don't know anything.
And you were presumably aware at the time that HUOBI's solicitors emailed a letter of claim to Tabarak on the 13th of February, holding Tabarak liable and seeking recompense for HUOBI's losses.
That's correct.
A very significant sum.
Yes.
So you'd agree that given the seriousness of the matter, this called for a proper investigation?
We have spoken to Christian and Anastasia after that.
I'm not asking what you did. I'm asking you to agree that given the seriousness of the matter, this called for a proper investigation by Tabarak.
Yes, it was proper.
And that really, given the seriousness of the issue, an external law firm really should have been the one carrying out the investigation.
I'm not really sure where that goes in all the other matters that I have got to give serious consideration to.
Now,
you're entitled, of course, to ask him what steps were taken to investigate and the like, but not
yes.
that particular question, all right?
Now, somewhat ordinarily, I would suggest, Mr. Malik, the very first time that there was any suggestion of any kind of investigation by Tabarak was in the course of Dr. Ahmadi's evidence. Now, according to the transcript of Dr. Ahmadi's evidence, he said various things. He said, we have done internally our admin, we did an internal investigation, and we have got reports on that, of the whole incident, what happened on that day. He said, we sat, me and my team, myself and HR and the compliance, we sat and we discussed the matter. We said what's happened and we know the story, and I explained that. He goes on to say, we only discussed about the incident of the 3rd of February. nothing before that, nothing after. Do you agree that that's is that consistent with your recollection?
There was many meetings between HR, myself and Dr. Mahdi, on occasions meetings between HR and Dr. Mahdi themselves. This was all discussed, and I believe this was also discussed with Christian as well after this has happened as well, on a couple of occasions as well. And yeah, I believe that many meetings were held.
Now, it was, he also confirmed, Dr. Ahmadi, that an internal report was prepared for internal purposes to understand what happened, what Christian's role had been, and whether he was in any way responsible for anything that happened on the 3rd of February.
There was no report produced.
Well, he says, really rather specifically, he said, it's like some one page of report.
It may have been notes from HR, but there's not a produced report, no.
Notes, you're saying?
Yeah.
Have those notes been disclosed? I don't think they have.
No, I'm not aware of it, no.
Have you searched for any notes?
We've spoken to HR, and there are no notes which, I believe the information which we had was simply that Christian's story as to what exactly happened, etc., on the 3rd of February. These were the main discussions, really.
So none of those notes, those contemporaneous notes or documents recording what you discovered, no such notes have been disclosed. Right. So in fact, Dr. Ahmadi's testimony saying that there was an internal report was wrong.
Maybe his definition of a report and the internal meetings was something different. His English is not great. He understands things differently. So you'd have to question that to him.
So as I understand, and please feel free to correct me if I'm wrong, the so-called investigation involved the following at most. First of all, solely a consideration of what happened on the 3rd of February. The events leading up to the 3rd of February were not considered.
No, I believe that, not specifically, but generally they were.
So when Dr. Ahmadi said, we only discussed about the incident of the 3rd of February, nothing before that, nothing after.
No, what I mean is that we discussed who these people were, how they met, etc., these types of things. So,
well, that is not what Dr. Ahmadi said. And it would be fair to say, would it not, that an investigation of all relevant documents in the run-up to the 3rd of February was not conducted. So you didn't check for emails and hard copy documents?
No, not me personally, no.
And nobody did in TABARAK in the course of that so-called investigation?
I believe IT tried to locate all this information afterwards, but I'm not sure.
You're not sure?
Yeah.
3 million bitcoins gone missing. The police have attended the offices. 2 employees have been taken into custody, and you're not sure whether you looked for documents that may be relevant to this when you were carrying out an investigation?
I did not know.
You didn't?
I did not know.
And you're not aware that anyone else did?
100% sure.
And you didn't take any steps to ensure that that happened?
I can only tell you exactly what I'm aware of and what happened.
No, I'm asking you a simple question. You didn't take any steps to ensure that all relevant documents were found?
No, I did not personally.
Despite the fact
He's answered the question. Let's get on.
Yeah. So really, what the investigation consisted of was some kind of chat about the matter between Dr. Ahmadi, HR, and you.
Not all the time, no. It was on occasions HR and Dr. Ahmadi, as I mentioned.
Yeah, so variously between those individuals. It was just a discussion, purely oral.
Yeah, and I believe, who else was there? Ahmadi, HR, myself, and sometimes I was not there, and sometimes HR was not there.
How long were Mr. Christian and his assistant in custody?
I'm not sure. I think it was one night or 2 nights. I don't know.
Only 1 or 2 nights.
Yeah.
And so after they were released from custody, they were available to be talked to and to be questioned.
Yeah, but it was difficult at the time because Anastasia had a difficult time when she went to the police station as well. So she wasn't too well to come to the office, if I remember. I think Christian came in after that. They were in shock, and it was difficult for them at the time. Obviously, we try to understand the situation. We can't just jump at them and say that you did something wrong. It's not nice to do that, especially without all the facts, and especially when Christian's saying that he was just monitoring what happened on the 3rd of February. It was a difficult time for them at the time.
And tell me, how long did this investigation take?
Ongoing. It was just ongoing. It was there were informal chats throughout.
So days, weeks, months?
Yes, weeks, months, even up till today. We're talking about it.
Right. And despite the fact that this investigation was proceeding for days, weeks, months, let me rephrase that. This investigation was proceeding for a long time, which would suggest, would it not, that you were not clear, that TABARAK was not clear about what had actually happened?
No, we once we got the information, we found out what happened exactly.
But you didn't have the information because you didn't look for hard copy documents. So
no, that's not the issue here. Hard copy documents. From the information we had, we're relying on the information that we had at the time.
And during the currency of this investigation, Mr. Turner and Miss Avialova were allowed to go about their jobs at TABARAK, meeting clients, and so on.
I'm not 100% sure whether they were meeting clients after that, but they were attending the office. I'm not aware of that.
Certainly you didn't prevent either of them. You didn't say to either of them in your role as compliance officer and risk management, head of risk management, you didn't say, well, while this investigation is ongoing, stay away from clients.
No, I didn't say that because I'm not allowed to say that to them.
And you didn't suggest to anybody, you didn't recommend to anybody at TABARAK that that happened?
No.
Now, can I take you to 8/5/20?
Yeah, I have that.
So these, as you may recognise, the memory, so-called memory minutes that Mr. Turner provided to the police, they're dated the 12th of February. Can I ask when you first saw these memory minutes?
I've seen these only recently.
Only recently. Now, okay. Now, in these memory minutes, he refers to a Navican account with TABARAK.
Okay.
Because the point was that a company called Navican at the relevant time did have an account with TABARAK, didn't it?
No, they did not.
Sorry?
No, they did not.
Right. So the existence of the Navicon account, you're saying, was a figment of Mr. Turner's imagination.
I'm sorry, but they're not a client of TABARAK.
Right, can we now go to 8528?
Yes, I have that.
Now, you're not copied into this email.
I'm not copied in on any emails.
No, I've got that point. Now, this is to the so-called buyer, Mr. Morozov, and HUOBI and Dr. Ahmadi and Isavyalova are copied in on this, but specifically Dr. Ahmadi. So Mr. Turner says, for example, at paragraph 2, and so the last sentence of paragraph 2, you and your Russian companions just misused our bank to convince HUOBI to enter the deal with Navicon. Which, okay. And then in the next paragraph, there is a reference to your account with us. So Mr. Turner clearly thinks that even then, as at the 16th of February, that Navicon or perhaps Mr. Morozov have an account with TABARAK.
They are not clients, they've never been clients.
And then in the final, the penultimate paragraph, Mr. Turner is talking about Mr. Morozov's responsibility also against us, TABARAK. Now, I accept, well, I don't accept, I hear what you say, that you didn't see this at the time.
Correct.
And I hear that you say that basically, in fact, you saw nothing until recently. So what you're effectively saying is that Dr. Ahmadi did not show you this email. He didn't forward you this email.
That's correct.
At the time. Don't you find that rather surprising, given the contents of the email and given your role?
As I mentioned, I wish I'd known.
So you agree that you ought to have been forwarded this email?
I should have been forwarded. I should have seen all the emails, not just this one.
Now, and had you seen this email, would you have still allowed Mr. Turner to carry on working at TABARAK?
I don't have the power to suspend or to do anything.
What would your recommendation have been as compliance officer, having seen that email? If you had seen that email at the time?
I'd seen the email at the time. I would definitely have spoken to Dr. Ahmadi to see what the hell's going on. Sorry, Bishop, I don't want to say hell, but I want to know what was going on.
Well, would you have raised with Dr. Ahmadi the question whether Mr. Turner ought to continue to be participating in the affairs of the company?
I would definitely have asked Dr. Mahdi to look into this very seriously and to definitely stop Mr. Turner from seeing any clients.
Right. Now, in a paragraph 15 of your witness statement,
Yes.
you say that because Mr. Thurner failed to provide Tabarak with his personal laptop upon leaving Tabarak's employment, it was only once I was able to review the documents produced by HUOBI that I began to piece together what had happened. But presumably you knew that when that on the 3rd of February, Mr. Thurner's laptop had been confiscated by the police.
Yes.
So, and he...
No, I found out before.
Was Mr. Thurner supposed to provide his laptop if it was with the police?
Well, once he got it back, he would have to.
Now, in the document production statement by your HR director, and that's at 1166.
Yes.
Paragraph 5 of that statement by your HR director says that Mr. Thurner and Ms. Saviolova used their personal laptops for work. They were permitted to do so as long as they allowed Tabarak to install and configure Tabarak's mail application, Microsoft Outlook, onto Tabarak's cloud-based storage device, which was Google Drive.
Okay.
Yes?
Yes, that's the issue, yes.
And you agree with that statement, do you?
Well, I didn't make the statement. It says HR and who's the person?
Presumably, as the person in charge of risk management and compliance, you would presumably have had a say in the security arrangements surrounding documents and data of Tabarak's employees. Or did you not do that either?
That's correct.
What's correct?
That we... Yes, they do use their personal laptops and undertake company business.
And there's a system whereby that provides for the storage of emails and work related to Tabarak being stored on Tabarak's cloud account, correct?
When it comes to IT, I don't know. That's a different department. I don't know how it's stored. I'm not great at IT.
Right. So, assuming that the documents, did you ever ask the question of how the documents were stored?
After the event?
Yeah, soon after the event, when the so-called investigation was being conducted.
Yeah, I did ask them how it's stored, and she said it's on some sort of different, something like that. I don't know exactly, I can't remember. But she said she wasn't 100%, it's IT who run this, etc., etc.
So you didn't think in your role as compliance and risk management officer to get to the bottom of how and where the documents were stored?
No, that's the IT. I've requested HR to obtain this information from IT. From the compliance officer doesn't mean I know where all the emails are stored and how they're configured.
Well, it's not rocket science, I would suggest to you, Mr. Mallet. You just have to ask some basic questions and apply basic logic.
I've asked her specifically where and how it's stored. Now, if my understanding is not great, I don't think that's my fault.
And you're also saying that you had no idea about the proposed addendum and invoice that had been provided by TABARAK to HUOBI.
Can I just say that I was not aware of anything. If I was aware, I would have been copied in on some email somewhere down the line. I've not been involved in anything whatsoever. I don't know anything.
So despite the fact that, let me ask another question. When did TABARAK first instruct lawyers in relation to the theft of the Bitcoin?
I'm not 100% sure. I don't know exactly the date.
Within a month of the theft occurring, or what?
I think it was a few days to a week or so. I don't know.
But shortly afterwards, yes.
I'm not 100%.
He may not.
Okay.
He doesn't know really.
But you would accept that one of the first things a lawyer would have told TABARAK is to search for and preserve all relevant documents. That would be normal.
I don't know what a law firm would ask me now.
Well, were you told either by the lawyers directly or indirectly that all relevant documents must be assembled and preserved because a case had been begun?
No, I wasn't told, no.
You weren't told that?
No. I wasn't really at the meetings with the lawyers.
Yeah.
And then you knew that TABARAK had received the letter before action from HUOBI's solicitors. February. And then you knew that proceedings had been issued against TABARAK.
Yeah.
And even then, you didn't take all steps you could to secure all the relevant evidence. That's what you're saying.
Well, Dr. Mahdi instructed a lawyer, so it's the lawyer's job to request information on what to do and what not to do. So it wasn't for me, it was for the lawyer.
So you don't see litigation risk or any kind of legal risk as being part of your risk management role?
No, this is why that Dr. Mahdi instructed a lawyer at the time, because I remember the first letter which was received was from the Dubai courts. And that's when he instructed a local lawyer and I remember the case was dismissed.
Now, according to your version of events, and given TABARAK's conspicuous lack of disclosure in these proceedings, it would be fair to say, would it not, that you failed as risk and compliance officer to take the very basic step of ensuring that TABARAK's Google Drive cloud account was checked and that Mr. Thurner's and Miss Saviolova's TABARAK account emails stored on there were secured? You would agree with that?
Well, I'm not responsible for the IT department. I'm responsible for the emails. We had requested through HR to the IT department to obtain these emails, etc., but I was not doing it myself, no.
So you took no interest in that whatsoever, despite your role?
I didn't say that either. As I said that I spoke to HR, instructed her to speak to IT to ask them to get this information.
And you didn't follow up on that?
Why do you say that?
Well, we haven't got the documents.
That's because I believe that they're not there.
Yes. Right. Now, as we know, you say in your witness statement that prior to the Dubai police attending, you were completely unaware of anything that had been going on.
That's correct.
So in your version of events, you knew nothing, you weren't involved in any of this?
Well, I wasn't, because I wasn't copied in on some email when I was involved, like everybody else was copied in.
So the purpose of your witness statement is what? looking at it, it can solely be to seek to persuade the court how tight TABARAK's compliance and risk processes are. Correct?
They have to be.
And therefore to seek to show that Mr. Thurner embarked on some venture with HUOBI that wasn't authorised by TABARAK.
I believe so. However, when it came to the 3rd of February, I'm not 100% sure whether Christian was involved or not, but from after him speaking to me, etc., he was just overseeing some transaction between the buyer and seller, and he simply stated that he was not involved. He had no involvement in it whatsoever.
The fact of the matter is, you're trying to persuade the court that TABARAK has tight compliance and risk management process.
I'm sorry to interrupt you again. You can't really put that motive to this witness. The witness has given his evidence, both in writing, and you have cross-examined. And the question as to the failures of disclosure complained of by you can then be looked at in the light of this witness's evidence. But I don't think you can put it to this witness that his motive was to, as you are suggesting. We take the evidence as it is. We know there hasn't been disclosure, and it's open to you to make your submissions.
The fact of the matter is, Mr. Malik, that TABARAK's compliance and risk management was slack and incompetent, wasn't it?
No, it was not.
And that you knew that Mr. Thurner and Miss Xavier-Lover had not done anything that was unauthorised by TABARAK.
Do I know what's on? That they didn't do anything wrong?
That they didn't do anything that they were unauthorised to do.
They're not authorised to do anything to do with cryptocurrency. They're not authorised to provide advice and assistance to any potential client without them being onboarded. They're aware of what documents are required for them to be onboarded. They're aware of this.
And in fact, you knew that TABARAK had encouraged Mr. Thurner to win the crypto-related business from HUOBI, didn't you?
How would I know that?
Well, your answer is no, I assume.
And you knew that all of, is the answer no to that?
That's correct, no.
And you knew that all of the due diligence documents requested of HUOBI by TABARAK had in fact been provided?
Not at all, no.
And you also knew that Dr. Ahmadi had agreed that the account opening fee would be paid from the transaction proceeds?
I didn't know anything at the time whatsoever.
Now, we know that Mr. Thurner, he says that Dr. Ahmadi informed him that you forced Dr. Ahmadi to sign Dr. Ahmadi's witness statement, that you were the one who was behind this.
Sorry?
Right. Can I take you to paragraph 34 at 7:59?
Yes, I have that.
And Mr. Thurner says, after reading the first witness statement of Mohammed Ahmadi, I was quite surprised about the allegations against me. As far as I know, up until late October 2021, at all times, Mr. Ahmadi has wholly agreed with me on my position in these proceedings and has told me in person at a meeting in or around the 23rd of October 2021 and otherwise that he did not stand by his first witness statement dated the 12th of October 2021 or his allegations towards me in his first witness statement dated the 12th of October, and that he was forced to sign it by Mr. Aziz and his counsel. And then he goes on to say, in fact, Mr. Ahmadi repeatedly told me he would like to fire his counsel for misleading him. But the point is here that it's Mr. Thurner's position that Dr. Ahmadi informed him that you had forced Dr. Ahmadi to sign the witness statement.
No, I'm sorry, that's incorrect.
Right. That concludes my cross-examination. Thank you.
Thank you. Now, can I just take stock of where we are with breaks for the transcribers? We've had one break, a quarter of an hour, and we're going to go on until 2 o'clock English time, 6 o'clock Dubai time. Do the subscribers have anything to say about a break between now and 2 o'clock London time?
I'm sorry, sir. Yes, please, if I could have a break, perhaps now, if that would be okay.
Yes, I think in the past we've had about a half an hour at this stage.
Yes, ma'am.
Yes, so we'll take a half an hour now. So we'll resume at 10 past the hour. Thank you very much. Do we have Mr. Malik?
Yes, Richard.
Yes.
Yes. I don't see him at the moment.
Mr. Malik, do you want to say hello?
Hello. Can you hear me? Yes.
I can see Miss Ahmed now. That's good. I'm still not seeing Mr. Malik. Maybe if he just moved the. It's usually sensitive to voice, isn't it?
Yes.
I'm actually here, but I'm not sure why the video is not working.
Ah, yes, I can see the witness. Yes, good. Well, now we move to cross-examination on behalf of the second defendant. So on you go, Mr. Matthew.
Thank you, my lord. Firstly, Mr. Malik, can you confirm that you have nobody but a trainee in your room?
Yes.
Yeah.
Sorry,
Yes,
she's not even a trainee, she's a paralegal, senior
Paralegal.
Yes, I can confirm
Sorry,
that.
Ms. Ahmed. Paralegal, correct. You are the Director of Compliance, Risk Management and AML of TABARAK, correct?
Correct.
You've worked in the field of compliance and risk management for 13 years, both
Yes.
as a compliance and MLRO, correct?
Correct.
And MLRO stands for Money Laundering Reporting Officer, correct?
Correct.
So if you have been a compliance officer and a risk management officer for over 11 years in DIFC and no DFSA regulations, correct?
No, I'm the compliance officer and MLRO, not the risk management. I'm not registered with that.
So it'll be correct to say that you have a thorough understanding of DFSA procedures and regulations as a compliance officer, correct?
Yeah.
You joined TABARAK in January 2014, correct?
Yes.
In your role as compliance director, compliance, risk management, AML, you oversee and ensure that TABARAK is compliant with its external regulatory and legal requirements set by the DFSA, correct?
Yes.
Your job is also to ensure that everyone at TABARAK is complying with internal policies and procedures of TABARAK, correct?
Correct.
You also work with Director of HR, Ms. Faludi, in relation to any disciplinary measures you might have to carry out to prevent and avoid a future breach of TABARAK policies?
No, not really. That's not my role. My role is simply to assist HR.
Okay. Can I take you to paragraph 6 of your witness statement, which is at 689?
This one?
When you're there, please let me know.
Yes, I'm here.
You say in the middle of the paragraph, in the event of such a risk being identified, I assist and provide advice to the head of HR concerning appropriate disciplinary measures that may help prevent and avoid a future recurrence.
Yes.
That's correct, isn't it then? You report to the directors and board members of TABARAK, correct?
Yes, correct.
Are you aware of any cryptocurrency related policy at TABARAK?
We don't have a policy on cryptocurrency.
But is there an unwritten policy at TABARAK?
A written policy on cryptocurrency?
No, I said unwritten policy.
Well, you mean is everyone aware of that we're not allowed to do it?
You must have heard Dr. Ahmadi's testimony, and Dr. Ahmadi, in his witness statement, has stated that there was an unwritten policy by way of which no one was allowed to deal in cryptocurrency transactions.
Yes.
Are you aware of that?
Yes.
And were you the person who managed this internal policy by way of training or by way of or email updates? Could you tell us how did you manage this?
By giving the employees information in relation to this orally.
Orally, okay. Can I take you to 8445, please?
Yes.
So this is the website of TABARAK. From the time when Mr. Turner was employed by TABARAK. You can see, if I take you to page 8447, which is a few pages down. So it provides the management team. Do you see that?
Yeah.
So management team is the CEO, Ms. Faludi, who is operations director, Mr. Khan, who is the finance director, yourself, the director of compliance, risk management and AML, Ms. Mutalova, client relationship manager, and then Christian Turner, who is the director of investments, correct?
Yeah.
So in response to my learned friend, Ms. Stewart's question, you said that Christian Turner was not supposed to call himself a director. You remember that?
Yes.
And if I ask you to go to the first witness statement of Dr. Ahmadi, which starts at 661. And I'll take you to the paragraph just in a second.
Okay.
Sorry, forgive me. 737. Second witness statement. 737. Forgive me, please.
Yes.
Have you read Dr. Ahmadi's witness statements?
Yes.
So if I take you to 737, paragraph 21, the last sentence, which starts with, given Mr. Turner's level of seniority, I permitted him to use title director, but it was understood by Mr. Turner this was not a directorship role of TABARAK's board of directors. And under no circumstances was Mr. Turner to imply anything of the sort when dealing with clients. So he was allowed to use the title director, correct?
Yeah, but he's not a member of the board.
But the question I'm asking is that, he was, because you called him a relationship manager, so he was authorized by Dr. Ahmadi to call himself a director, and his signature block in his emails correctly said he was director of investments, correct?
Yes, but he's been called an investment manager occasionally. He's been called an RM by myself on occasions. So I don't see the relevances in this, with the wording of director. I don't understand.
The point is that he was allowed to call himself a director, and when contacting clients, introduce himself as a director.
Okay.
Are you aware of? Did you hear Dr. Ahmadi's testimony on seals of Tabarak?
The stamp.
The seal.
Yeah, the stamp.
Yes. Okay. I mean,
yeah. Yes.
His lordship basically distinguished stamp from a seal. If I take you, for example, just to show you. If I take you to 841, please.
Yes.
So if you go to the last page of this employment agreement of Christian Turner, which is at 846, so a few pages down.
Yes.
So you'll see Dr. Ahmadi's signature, Christian Turner's signature, and there's a seal of Tabarak.
Yes.
So in his testimony, Dr. Ahmadi said that the seal, only 3 people have possession of this seal. Yourself, Dr. Ahmadi.
Not myself.
Not you?
No, HR, the finance officer.
Please, you can redirect him if it's needed. It's
well, put to him what you say, Dr. Ahmadi said.
So
take it from there.
Yes, but Dr. Ahmadi said that the seal remains in the possession of himself, which is Dr. Ahmadi, with Ms. Faludi and Mr. Aziz, the finance director, correct?
Finance director.
Sorry, Mr. Khan, the finance director.
Yeah, that's correct.
Yeah. So if a seal has been put on an account opening form, which Dr. Ahmadi said that he would be the person who would put the seal on it, would you say that that would be that it would be correct to assume that he would have sealed the agreement?
This agreement?
No, I'm saying he said whenever a seal is put on an account opening agreement, it will be done by me, and if you see a seal on an account opening agreement, would you think that Dr. Ahmadi must have sealed the agreement?
Yeah, he would sign it though.
Well, he would sign it. But if it's sealed, would you assume that it's sealed by Dr. Ahmadi?
I don't know. It has to be sealed by Dr. Ahmadi. It has to be signed by Dr. Ahmadi.
But if there's a seal on a document, it would be sealed by one of the 3 people in possession of the seal, correct?
But the issue is that the seal is in 3 offices, and they're on their tables or their drawers, and you could walk into them and take that if you wanted to. So they're accessible, but all I'm saying is that usually for an account opening agreement, Dr. Ahmadi would sign and seal this form. So I don't know what your question is now.
Well, the question was, if you see a seal on an account opening form, it would be one would assume from Dr. Ahmadi's testimony that he would have likely sealed the agreement, correct?
Yes, if his signature is there.
Yeah.
The signature has to be there.
But if his signature is not on the agreement,
I
then
wouldn't know. I wouldn't know them.
then who would have sealed the agreement?
I don't know.
Okay.
I think the highest you can put it, Mr. Matu, is that there would be a preliminary inference, a prima facie inference, that the seal has been officially put on, that may be rebutted in particular circumstances. And I think your case is, look, there's the seal. It's reasonable to infer that must have come on with the authority of Dr. Ahmadi. And what you're faced with is, well, that can be no higher than a rebuttable presumption. And the argument goes, as you know, that based on the evidence of Dr. Ahmadi, that it wasn't put on by him, and it must have somehow or other been put on by someone else without authority. So I think we can move on.
Thank you, my lord. Now, can I ask you a few questions about the investigation? The investigation after 3rd of February 2020 that was conducted by you, Dr. Ahmadi, and the director of HR, Ms. Faludi. You were part of the investigation in relation to the Bitcoin transaction, which ended in theft of 300 Bitcoins, correct?
Yeah, but I wasn't there always.
According to Dr. Ahmadi, you were one of the three who conducted the investigation, correct?
I wasn't in attendance at every single meeting.
And Dr. Ahmadi and Ms. Faludi unanimously reached a conclusion that Mr. Turner was not responsible for the buyers stealing the claimant's 300 Bitcoins, correct?
No, I'm saying that I don't have evidence to suggest that Christian was involved. I don't believe personally he was involved in the stealing of Bitcoin, because the reactions from everybody after what happened was just, we were in shock as to what happened afterwards. So I saw the state of Christian and I saw the state of Anastasia, and it's wrong to suggest that they were the ones responsible for stealing the Bitcoin. Afterwards, the police did an investigation. They dismissed that, and the court dismissed it against Christian for stealing it. But thinking about it, going back, you know, things could have been done differently. You know what I mean? If you think about what's happened, how we conducted the investigation, etc., they should have been much better. But we were all in shock. We were surprised by what happened, and you know, we were a small group of, you know, employees together. Everyone knew each other quite closely, not that person, but personally, generally. And it was a huge shock, especially when we found out that Anastasia, as a lady, was arrested. You know what I mean? It's not a nice feeling, obviously, in a Dubai police cell. So we were in shock about everything. So I don't know whether he was involved, but I don't think he was involved in the Bitcoin being stolen by him. No, I don't think so.
Because Dr. Ahmadi, in his testimony, said, when I asked him a question, I asked him, had Christian Turner been released by the time when you conducted this review? He said, I can't remember, to be honest, I don't remember. Then I asked him, and your conclusion was, after conducting this investigation amongst yourselves, that Christian did nothing wrong on 3rd of February 2020, correct? Then he answered, it's not that he did nothing wrong. We came to a conclusion that Christian Turner is not behind the disappearing the coins. So you reached a conclusion, correct?
Well, even from up till today, I don't know what happened exactly. Who stole the coins, how they were stolen, I don't know. But after Christian was released from the police, I've spoken to Christian many times after that, and he genuinely felt very hard done by, you know, being accused of stealing coins. I don't believe Christian as a person would steal these coins, no. And we were always talking and investigating. When I use the word investigating, it's more about discussing this with Christian. Sometimes I would speak to him and ask him how it happened, what happened, etc. afterwards. And, you know, he was very remorseful about, you know, how this occurred. And, you know, he wanted to resign. I remember him, he resigned. he handed a notice, and I'm not sure whether Dr. Amadi said, look, just stay on, let's see what happens, let's see where this is going. And I don't believe that he saw any clients after that, but he was on the visa, if I remember, and we wanted to get to the bottom of this, so we obviously wanted Christian close to us, to see what happened after everything. Because imagine we fired Christian, then how would we get information from Christian in a nice manner? It would be very difficult to get this information from him. My discussions with Christian after this happened, he was really being honest with me, and he was explaining to me that I don't know how this happened in the meeting. I don't know why they arrested him. They should be going after the buyer as well. These guys were involved. It was a difficult time for everyone, not just us, but especially for the two who were arrested. It was really tough.
Did you produce this report of this investigation, or the findings of this investigation,
No.
after Christian was released, or after questioning him, or before questioning him?
We started discussing this the day after he was arrested. So he was arrested, I believe, in the evening, and he was there overnight. I think they were both there overnight. And I came to the office in the morning. We found out everyone's standing around, what's going on, what happened, you know, this and that. And we started discussing it. And then even when Christian was released, we started discussing it. And we were ongoingly discussing it.
And did you share this report with DFSA, with police,
There's no report on
with
this.
anyone?
There's no report on this. There's no actual written report on this at all.
But you did mention to Ms. Stewart that there were some notes or
Just, I believe, HR's general notes about what's Christian saying, but that I think that was it. But there's no actual report on it, because we can't blame somebody where we don't have the evidence against him. And you know, it's difficult to blame somebody like who's in the office and somebody like Christina Anastasia, and you know, going through everything they went through. You can't blame this coin being taken, and it was wrong, and we needed him with us.
But Mr. Aziz, you are the compliance officer of TABARAK,
Yeah.
and you know your role is to protect the company before any individual.
Yes.
And it's not that somebody had gone to jail and had been arrested. It was a significant event for this company that this had happened. So it was your duty to get to the bottom of this, correct?
We tried to get to the bottom of everything. We tried to find out what happened. We tried to find out how it happened, a result of everything. And truthfully speaking, if I could go back, I would probably do things a bit better, definitely. But we were all like in a panic and shock as to what happened and stuff. So.
But did you ask Dr. Ahmadi what he knew about this transaction?
From my understanding, from when I spoke to Dr. Ahmadi afterwards, he said that I've always told them not to, they haven't provided us documentation, we ceased to get involved with this company because they didn't provide us any documentation in terms of due diligence and everything else. And he said he spoke to Christian to tell him, stop all this and these types of things.
Did you, surely you must have asked him how you communicated with Christian on these, on this, in relation to this transaction?
I didn't specifically ask him how he communicated. I asked him general questions about what happened. I didn't say, so how did you communicate with you and Christian, via email or via phone or via something? No, I didn't do that. It was really general, and I'm really trying to be forthcoming with everything, really honest, and try to tell you that it's how it went. It was more discussions rather than anything else.
But were you not interested in asking everyone in the organization, does anyone have any documents, any information that can be provided to me so I can get to the bottom of this from the compliance angle of things? Yeah,
the issue is this has now happened. So February the 3rd has happened. I'm speaking to HR to say, asked them to try to get as much information as possible from their laptops, etc. Laptops were taken to the police station. We didn't have, we couldn't get anything out of that at the time. And the phones, I think, if I remember, she told me the phones.
What about your Google Drive?
I don't know. I spoke to HR how to get this information and how to get IT to get this information. I'm not 100% sure as to what they did and what they did not do.
Mr. Aziz, I put to you, this was a significant event. I would say it's an extraordinary event in any company's life for police to come for its 2 of its 5 employees being arrested. So it's something you can't just say that I just spoke to IT and I'm not an IT person. It was your responsibility to unearth everything about this, correct?
But you need to understand, it's not my fault that this all happened. I might be at fault for not requesting certain documents, that's fine, but it's not my fault that this happened in the first place. I can't monitor every single person in the office, go to their computers and keep checking them. If I was aware of anything, that would be copied in by Christian at least once to a compliance officer at HUOBI. At least once I would sign the application form where it says to be signed by compliance officer. Why was I not asked to sign this document? I just want to say that I've sat through all of this evidence, going through everything, and I'm just trying to think where my shortcomings are in relation to how this happened, because I genuinely believe that I'm not aware of anything. I'm not aware of anything of what happened. I'm finding out about everything after the events. So the events have already taken place. We have procedures in place. You cannot onboard a client without documentation until I sign off. You cannot advise a client. You cannot provide services to a client. If the RM or the investment manager, whoever the person is not doing it, I can't stop unless I'm aware of it.
Mr. Aziz, at that time, around 3rd of February, it doesn't appear that there was any significant amount of business activity in TABARAK that you would have not known about what's happening in TABARAK. There are people coming to see Mr. Turner regarding this transaction. There are, according to Dr. Ahmadi, people sit next to each other. It's an open plan office. So surely you must have by osmosis come to know something about this, correct?
No, it's not an open plan office. The offices are segregated and there's no door in between each office. So somebody to come to my office would come through those imaginary doors and they would walk through. Now, every office is separate in a way. It's not open plan like you have those desks and somebody sitting right opposite you. We don't have that. We have separate offices and nobody can come to my office to look at my files, go through anything because they're compliance documents, they're private documents of mine. So I don't even allow people to come into my office and to even have access to my computer. Now, if I'm aware of somebody walking into the office, if somebody's walking back and forth, I look up, but I don't know who the person is. To date, if I was to have the HUOBI claimant in front of me, I still don't know what he looks like because I don't know who they are. I will never get involved in a client. I will never see a client, but I will speak to a compliance officer directly if they require documents from us.
But after the event, you would agree that as a compliance officer, you would have wanted to see everything that TABARAK had in hard copy files for this.
Yes, I actually went to Christian's room and I saw the files because I don't have files on HUOBI because they're not a onboarded client. So I would have my own file if they were a client of mine in my own cabinet. But the RMs keep their own files in their own cabinets in their own rooms. Sorry, my lord. RMs, I mean relation managers, investment managers, anyone in the office. I went to his room, I think it was the day that we came in the morning, and I checked their files, and I went to the cabinet, and I saw HUOBI written on the side of the file, and I went through it, and there's these documents, but do you know what I mean? It's a shock to me, you know what I mean? They're onboarded. Usually, an RM would keep files in their cabinets, even if they're not onboarded. They're potential clients, potential.
So you saw the HUOBI, should I say, working bundle of documents? I mean,
it doesn't say working documents. It's just a file. It had HUOBI on the front, and it had documents inside.
But did you not review those documents? When
Yeah, I said, what are these? You know, I went through them. They were incomplete.
What date was it when you saw these incomplete documents?
The day that I went to the office in the morning, I just checked everything because.
So that would be 4th of February, right?
Because they're arrested and they're saying HUOBI is involved in this. So I need to check who are HUOBI. So I'm going to check.
So it'll be correct to state that when you were having this discussion, investigation, the three of you, Ms. Faludi, yourself, and and Dr. Ahmadi, you must have discussed these documents.
I said to them that this is incomplete. The file is not complete. They are not onboarded. I checked my records. They're not onboarded because every quarter we file EPRS, which is the Electronic Prudential Reporting System, to our regulators, and you have to insert in there details of clients. And I've never inserted details of clients of HUOBI.
Okay. The point is that you were aware of the documents concerning this transaction, even though they were not onboarded, but you had a set of documents which would give you understanding of this matter to an extent, correct?
On the 4th, you mean, on the 4th of February?
On the 4th of February.
The only documents which were inside that file were, I believe, incorporation certificate, a couple of passport copies. There was no source of proof of funding, which is very important because the source of proof of funding is the main issue when it comes to clients being onboarded, because their source of funding, we have to go back and see where they generated their income, generated their money from. And if we're not satisfied, it could have been through some terrorist means or through drugs or through various other weapons, etc., etc. We cannot take the client on. So they're never in the file. They were not in the file.
But was the account opening form in the file?
If I recall, there may have been one. I'm not 100% sure. I can't tell you right now that there was. I can't remember. Because
you have not covered this in your witness statement, correct?
I can't remember. No, if I haven't, I haven't.
And now coming back to this, so in your witness statement, you say, because I just want to clarify one point from your witness statement. You say that at paragraph 15, which is at 693.
Yes.
I'll just read the first sentence because everything else flows from it. Since 3rd February 2020, I've been trying to ascertain precisely what happened in the lead up to that day. Mm-hmm. So you had some documents to rely on to what happened on that day, what this concerned, what were they trying to do? So surely Dr. Ahmadi, during your discussion, must have said, Christian was copying me in some of these emails concerning this. Did you not have any discussion on those emails with him?
Not on specific on the emails, but I did speak to Dr. Mahdi about this. Yes, definitely. I asked him how this happened, how this ran up to this event, and he was adamant that I put a stop to everything. I've stopped Christian from doing anything. They can't do anything without being onboarded. This is all that happened.
And did he say how he put a stop to all of this?
He told me that he spoke to him, I know that, and I think he's sent him a message or an email, I don't know.
And none of these documents that you found in Christian's office, sorry, Mr. Turner's office, on 4th of February were disclosed by you, correct?
Which documents?
The documents you found in Mr. Turner's office concerning HUOBI.
It was just the incorporation certificate of HUOBI and the copy passports of individuals. These were the main things, I think.
And I suppose account opening form and perhaps a copy of the addendum, perhaps?
I don't know about that. I can't say 100% about that. I don't remember that at all.
And did you retain that bundle of documents?
No, I put them back in the cabinet.
Okay. Now, after the incident of 3rd of February 2020, you say that you have been a DFSA, you've been in DIFC for over 11 years and have a thorough understanding of obligations as a DFSA regulated. You've been a compliance officer for DFSA regulated firms. So did you know that if there's a police matter, you're supposed to give information to DFSA, to report to DFSA about this?
A police case?
Because there was a police had come to your offices that arrested your employees. And did you report this to the DFSA?
Not at the time, no, not at the time.
But did you ever report this to the DFSA?
They are aware of it when we had a conference call towards when this case has been materializing afterwards.
And when was that?
That was in the end of the year.
So towards, let's say, December 2020?
Bit before that, I think.
And did you ever write an email to DFSA providing them information on this?
No.
Or providing them any kind of perhaps findings of your report?
No. We've told them that this incident occurred because at the time they were speaking to us about Christian at the time. They went to a conference call about that. And we gave them information about this has happened, etc. The Dubai court has dismissed the case, and this is following on from another case afterwards. No.
But after the police and the CID arrived at the offices and arrested Anastasia Zavlova and Christian Turner, you did not take any steps to report the incident to DFSA right away, correct?
No, that's correct.
You agree that that was not as per the DFSA regulations, correct?
Where does it say the regulations that you have to report a matter when police arrest somebody? I don't understand.
Because I would expect that as a DIFC company, if there's been a fraud in your company, and if there has been an arrest because of that fraud in your company, you're supposed to inform the DFSA. It's in the DFSA handbook, I think.
The issue was they were never a client of ours. They were never on board as clients. We were not providing any service to them. Compliance has not signed off on this. So at that time, they were never a client of ours. They simply came to the office to say, can we just use your room independently? That was it.
But Mr. Aziz, I'm asking a different question.
No, you're asking me why I didn't report this. This is the reason why I didn't report it.
But the fact is, the incident happened in your offices.
Okay.
It involved two of your employees who were working as employees of TABARAK on 3rd of February 2020. So it was incumbent upon you to go and report this to DFSA, correct?
No, I've already explained the reason why I didn't.
No, the point is, you under the regulations, you don't choose when and decide when DFSA should know or not know. You should make the first move and inform them, report to them.
You're talking about regulations. I don't understand which regulations you're talking about.
DFSA handbook. There's a DFSA handbook which says, how do you handle, your company, details. If there's a significant event, you're supposed to. It's your obligation to inform DFSA. Correct? You've been a DFSA, compliance officer for 11 years.
Yes, but the reasons, maybe my shortcomings were I should have informed. However, the reasons were because of how I've explained it.
Okay. Now, can I take you to 8655?
Yes.
This is basically a account opening agreement, which is like your default agreement that you amend on case-by-case basis, correct?
Yeah.
And you say at paragraph 8 of your witness statement, which is at 690.
Okay. Yes.
The last two sentences of paragraph 8. You say in this template, which is the template at 8655, the due diligence administrative fee is set at USD 30,000 plus VAT. However, as I mentioned above, the final amount is set by Dr. Ahmadi at the time the agreement is being finalized. So from your witness statement, it's correct to state that Dr. Ahmadi has power to amend this agreement the way he chooses to, correct?
Yeah, correct.
So no matter what your policy might be or your internal controls might be, Dr. Ahmadi as CEO has the capacity to overrule all those things, correct?
Well, no, not really. In terms of the policies, he can't change any policy or procedure. He's not allowed to do that. He's not allowed to change anything which states in the DFSA rules, etc. set out. You can't do that. You can change how much to charge.
If I can rephrase my question, Dr. Ahmadi can decide in what way this agreement will be agreed, correct? On what terms, for example?
The terms, you mean after the information concerning the due diligence, etc.? Is that what you're talking about, the services?
Well, he can wait. I mean, he can decide if due diligence is adequate or not.
No,
correct?
Not allowed. Not allowed.
He can decide how, in what way the remuneration for a transaction will be undertaken, correct?
You mean for the onboarding fee, the due diligence fee?
Yeah, onboarding fee or fees for a transaction.
No, transaction I don't know. I'm talking about the account opening agreement. I'm talking about the due diligence fee. He has a right to change and whatever he wants to charge.
And it's correct that normally you would not be involved in his decision making of these issues, correct?
Yeah, of the fees, yes, correct.
And what he decides with clients or prospective clients, you would not have visibility on that, correct?
Right, yeah. Because I'm not I'm not CC'd.
Because it's correct to say you're not the front office of the investment bank, correct?
Oh, that's correct.
Given, I want to again raise this point because as compliance officer, your job is to ensure, is to understand what everyone is doing and to ensure that they are doing, they're making sure the company is in good standing and the controls are being applied properly and implemented properly. Isn't that right?
Yeah, but I can't mind the children if they're not doing what they're told.
But in a company, as I said to Dr. Ahmadi, that TABARAK was not a Goldman Sachs. It's a much smaller organization where you can see end to end all the people every day, and right now you have only 3 people. At that time you had 5 people, and at the most you would have some understanding of what everyone is up to. That's your job, to know what is everyone doing in this bank.
Yes, well, I don't search their computers. There's trust. We have to trust. He's a senior person. He's an investment manager. He knows the rules. He knows what he's doing. Everyone knows what their roles are. You can't babysit.
But that's why you audit, right? That's why you ensure every 3 months I will check what everyone has been up to, correct?
Yes. What I do every 3 months is I don't ask them, give me your emails. I ask them, have you got information about any clients, potential, etc., etc., anything coming in the future, general information, not specific. And if there's a new client, I will know about the new client because I'm onboarding the client.
But generally, you'll have discussion with them every quarter, as you said. What clients you're trying to, what are the prospective clients? Who are they? Or no?
I don't get information as to the names of the clients. I don't get information as to what they're doing, etc. This has been going on for years and years, where RMs previously would send me the odd one document from due diligence and say, could you run a check on this potential client? And I'm saying, why should I run a potential check on one document when you fail to provide me with all the documents which are requested? I'm not going to waste my time as usual. So what they're supposed to do is get every single document, come to me and say, this is a potential client, here you go, do your job.
So every 3 months when you carry out this audit, what would you do? So you'll meet everyone and then you would check the hard copy files, right?
It's not an audit every 3 months. It's an EPRS where you file with the DFSA, and it's the responsibility of the finance officer.
So EPRS.
And the finance officer will speak to me and ask me, are there any new onboarded clients? And I will give him the information.
So as a compliance officer, I'm trying to understand, how would you monitor people and your employees, make sure the organization is well well sourced, and it's the compliance controls are being are well applied in the firm? How would you do it if you wouldn't audit and check the files from time to time?
The only files that we check are files which have been onboarded. I'm not going to check a file which has half a document set for a potential client. I will never do that.
But you would agree, you keep on calling Mr. Turner RM, and that's fine. Yeah, I know it's your internal language, but it's correct to state that when Mr. Turner was working in 2019, 2020, he was the only director of investments and only RM at that time, correct?
No, I think Nicole was there as well. We had another staff member.
Was Nicole an RM? Because her, as I showed you, her title was Client Relationship Manager.
The same thing.
Okay. So there were essentially 2 RMs, according to you, correct?
Yeah, if I remember, yeah.
So there were not that many RMs for you to not understand what they are up to from time to time. I mean, I'm sure every 6 months you want to see, because as you would give them compliance training, right? You said you would give them compliance training, workshops, correct?
Yeah, it's correct. And even if an informal meeting, just going to them, speaking to them, oh, by the way, there's a new law out, you can't do this, you can't do that. A new media bulletin has come from the DFSA, you can't do this, or many things like this, just general.
As a compliance officer, you're there to mitigate risks, to ensure there are records, to ensure that people who are employed by the company are following the rules of the company, correct?
Yeah, if I'm aware of them.
Sorry, what do you mean by aware of them?
Well, if I'm not aware of something, then how would I to know if anything is forthcoming?
Essentially, that would be your job to basically investigate through different means, isn't it?
No, not really.
Through basically asking them questions off and on. That's what a compliance officer does, to prepare a report for the board of directors as to how the compliance function is working in the company. Do we want to make any changes? Isn't that right?
I don't need to speak to an RM to give my compliance report.
But when you would go to the to board of directors, I'm sure you would attend some board meetings in the year, correct?
No, I'm a board member. I can't attend a board meeting.
So would the board members never invite you to the board meeting to present on compliance issues in the firm?
No, the only time that I do see them is when they come, and if there's any relevant change in laws, etc., then I would just make them aware of it, but I'm not allowed to attend a board meeting.
So when the incident of 3rd February 2020 happened, there must have been an extraordinary board meeting to discuss that incident, correct?
There may have been, yeah, the board meeting following the incident.
And I'm sure they must have asked compliance function, how did this happen?
No, they didn't really ask me specifically how this happened, because I wasn't aware of how this happened.
But it's inconceivable that a incident of this magnitude happens in an organization of 5 to 6 people, and the person who's supposed to police the whole organization is not asked what happened. Have you done an investigation? And which you had, in fact.
I believe Dr. Ahmadi might have spoken to the board in relation to this, but I didn't directly speak to the board, no.
Did Dr. Ahmadi discuss ongoing matters with you at all during the course of every month, every year?
No, general discussions about things, but not specifically on specific potential clients, no. But he did say sometimes, I have a potential client, I'm just waiting for him to provide me the documents. Once I get the documents, I'll send them to you, go through everything, general things.
So you would agree that Dr. Ahmadi will talk to you about any potential clients, correct?
Yeah, his potential clients, yeah.
Or even could be potential clients, correct? Because
nobody else is. He would only discuss his potential.
how often would you communicate with Mr. Turner?
In the early stages of the his employment, quite often, but it wasn't really on a. It was more personal. Hello, how's things? General. Because you know, it's a small knit office, and everyone's talking to everyone. So it was nice. Everything's fine. But when it comes to work, I would be the one trying to approach him to you know, tell him about things and tell him about the office, tell him about any laws, etc. But generally, everyone's talking to each other generally every day. But it doesn't mean that they're talking to each other professionally about specifics on potential clients.
I want to ask you a few more questions about the seal. So, as a director of compliance, you must have a seal is something that's you know, discussed in your articles of association. It's an important piece of corporate for corporate agreements in UAE to have a seal. So surely the policy of seal being accessible to everyone is a compliance risk, isn't it?
But it shouldn't be accessible to everyone. They should be locked away in their drawers.
And were they locked away by people who three people who had them?
I don't know at all times whether they were. What I do know is at the end of the day, they were definitely locked. I'm sure 100% that's from me seeing personal from HR. I've seen do that, and I've seen the finance officer do that. I don't really go into Dr. Mahdi's room for this, but if I was walking into Kadir's room, he would definitely lock it at the end of the day, and so would HR. But during the day, it's open.
Were you aware that BTC transaction was going to take place at Tabarak's offices?
Oh, no, not at all.
Where were you on 3rd of February 2020? Were you at the Tabarak offices?
No, I was, but I was in and out of the office, definitely. I was in and out of the office.
And did Dr. Ahmadi mention to you that there's something happening that day, or any other person, Miss Faludi or anyone else?
No, nothing at all. You know, when it comes to something like this, I'm scared of crypto. I don't want to, you know what I mean, put anything to it. And I wasn't aware of anything. I don't know who, you know, when it happened in the office, what time they came. I don't even know.
As a compliance officer, when Mr. Turner and Ms. Zavilova were arrested, did you think about going to police station and ensuring that a statement is given to you or to the police, and you keep a copy of it for your records?
No, in Dubai, it's a bit difficult to go to the police station when somebody's arrested. I think only lawyers may be allowed to go. But I only found out the following morning anyway. I didn't know, you know, but I was very, very upset about them being arrested. Yeah, definitely. I felt very bad.
Mr. Matu, it's 6 o'clock.
Yes,
2 o'clock London time. Give me some idea of how much longer you're going to be with this witness.
Just 1 more hour.
Another hour?
No,
well,
just one more.
1 more hour. Yes, I follow. Well, I think we'll adjourn now.
Yeah.
And you can pick up the threads again. Now, we meet again on the 9th.
That's right.
I want to see some nods of approval to make sure I've got the right date. I think I have. It's so we meet again on the 9th at the usual time. Now, Mr. Malik, when a witness hasn't finished giving his evidence, but the court adjourns, you're under a strict obligation not to talk to anybody about the case at all. That's anybody, any lawyers, anyone from the firm, not even members of your family. You can talk about everything else. It may be a relief to you not to talk about this case. So that's the rule, and I must ask you to abide by it.
Of course.
Very good.
Your Lordship, break, sorry to interrupt. So in terms of starting on the 9th, there had been some discussion about starting at 8 o'clock UK time and 12 o'clock Dubai time, because the parties have agreed that the first defendant's expert will give his evidence first, and because he's in Cuba, and you'll recall the 12-hour time difference, he's only...
Oh, yes.
So,
okay, well, will 8 o'clock do the trick if we meet at 8?
Yes.
Right. Well, I'll ask the registry to make sure I'm reminded that the proceedings on the 9th will begin. That's on the Thursday of this week. Will begin at 8, and we'll begin at 8 for that reason. Thank you for your intervention.
Very cool. Thank you.
Fine.
Thank you, Mark.
Right. Well, I wish you goodbye, and I shall see you on Thursday.
Bye-bye.
Bye-bye.